Hello, check 1 2 3. Hello, 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 check 1 2 3. Hello, hello, hello. ఓకేనే లేదండి టైం పడుతుంది లైవ్ కదా
Akshita, deem it as my great honor and privilege to invite the dignitaries onto the dais.
I request the Honorable Sri Ganta Ramarao Garu, Chairman Bar Council of AP and President of today's seminar, to come over the dais, adore the chair. I request Sri Ram Mohan Rao Garu to accompany Sri Ganta Ramarao Garu and BBA to Honorable Chairman Sri Ganta Ramarao Garu. Thank you, sir.
Now, I offer the chief guest of today's meeting, Honorable Sri Justice Akula Venkata Seshasai Garu, Judge, High Court of Andhra Pradesh, to come over the dais and adore the chair. Lakshmi Garu to accompany Honorable Sri Justice Seshasai Garu, and I also Rao Garu, Vice to present a sapling to Honorable Sri Justice A.V. Seshasai Garu. Thank you, sir.
I request the Honorable Sri Justice U. Durga Prasad Rao Garu, Judge, High Court of Andhra Pradesh, to come over to the dais and adore the chair. Sir will join us lately. And Chakravarti Garu, Judge, High Court of Andhra Pradesh, to come over the dais and adore the chair. I request Garu, and I request
Thank you, ma'am. Now, Sessions Judge, Srimati Aruna Sarika ma'am, to come over to the dais. Ma'am will join us shortly. Now I request Vice Chairman Bar Council of Andhra Pradesh, Sri Rama Jogeshwar Garu, to come over to the dais and adore the chair. Srimati Sri Lakshmi Garu, member Bar Council of Thank you, ma'am. Now I request Srimati to present a sapling to K. Ramarao Garu. Thank you, ma'am.
I request the Honorable Member, Bar Council of India, Sri A. Ramireddy Garu, to come over to the dais and adore the chair. Sir will be accompanied with B. Ravi Garu, Bar Council of India. I request Sri P. Anjaneyulu Garu, Sports Secretary, to present a sapling to A. Ramireddy Garu.
Thank you, sir. Now I request Honorable Member Bar Council of Andhra Pradesh, Sri Chalasani Ajay Kumar Garu, to come over to the dais and adore the chair. I request Sri K. Koteshwar Rao Garu to accompany Honorable Member Bar Council, Sri Chalasani Ajay Kumar Garu. Welcome, sir. Now I request to present a sapling to Sri Chalasani Ajay Kumar Garu. Thank you, sir.
I request the Honorable Member, Bar Council of AP, Sri Sunkara Raj. Request G. Bapuji Garu to accompany the Honorable Member, Bar Council, Sri Sunkara Rajendra Prasad Garu. Thank you, sir.
Now I request the Honorable Member Bar Bar Council of Andhra Pradesh, Sri S. Malleshwar Rao Garu, to come over dais and adore the chair. I also request Babu Garu to present Malleshwar Rao Garu, the alumni president. Sir,
I request the President Sri K.V. Sundar Garu to come over to the dais and adore the chair. I request to President Bar Association Vijayawada.
now I request C.H. Divakar Babu Garu to come over to the dais and adore the chair. A sapling, Babu Garu.
I request Dwaraka Nath Bar Council.
C. Nageshwar Rao Garu, member, Bar Council, Vijayawada, to come over the dais and the chair. Thank you, ma'am.
Now we shall have the prayer song.
ఉందని ఇప్పుడు ఏంటంటే యాక్ట్ అనేటువంటిది కూడా ఒకటి తీసుకురావటం, తద్వారా దాన్ని కూడా ఏంటంటే ట్రిబ్యునలైజేషన్ చేసినటువంటి మనందరికీ తెలుసు. దాంతో కఠినతరమైనటువంటి చట్టాలని దాని భాష్యం చెప్పడం న్యాయమూర్తులు కాకుండా ఐఏఎస్ అధికారుల చేతుల్లో పెట్టేటువంటి విషయం కూడా మనం గమనిస్తూ ఉన్నాం. వీటన్నిటికీ నెపం ఎవరి మీద? న్యాయ వ్యవస్థ మీద వేస్తూ ఉన్నారు. ఎందుకంటే ఆలస్యం జరుగుతూ ఉన్నది. ఆలస్యం జరిగినందువల్ల ఈ వ్యవస్థ మీద ప్రజలకు నమ్మకం పోతా ఉన్నది. కాబట్టి మేము ఈ పనులు చేస్తున్నామని చెప్తా ఉన్నాం. మనకు కావాల్సింది ఏదో ఒక తీర్పులు కాదు, చట్టపరమైనటువంటి ఆశల ద్వారా వచ్చిన తీర్పులే కావాలి. కాబట్టి ఏదో ఒక తీర్పు కావాలంటే మనకి సందుకు నలుగురు దొరుకుతారు, పెద్ద మనుషులు కానీ మిత్రులు కానీ. కానీ అటువంటి తీర్పులు మనం ఆహ్వానిస్తాం. అది వ్యవస్థకు మంచిది కాదు అనేటువంటి విషయం కూడా మనం గమనించాలి. అందుకని న్యాయవాదులుగా, న్యాయ కళాశాల విద్యార్థులుగా మారుతున్నటువంటి చట్టాలు ఈ యొక్క వృత్తి విలువని కాపాడడానికి కోసం మనం నిరంతర అధ్యయనం ద్వారానే మనం దీన్ని సాధించగలమని, మనకున్నటువంటి మేధస్సు ద్వారానే ముందుకు పోగలిగినట్టే, మనకున్నటువంటి లైఫ్ పవర్ కాదు కావాల్సింది మేధస్సు అనేటువంటిది కూడా మనం గమనించాలని చెప్తూ ఈ సెమినార్ని యువ న్యాయవాదులు, న్యాయ కళాశాల విద్యార్థులు ఉపయోగించుకొని ఈ విలువలు నేర్చుకుంటారని చెప్తూ మీ అందరికీ
నమస్కారం. ఈరోజు సిద్ధార్థ లా కాలేజ్ మరియు బార్ కౌన్సిల్ తరఫున ఈ సెమినార్ని ఏర్పాటు చేయడం అనేది చాలా అభినందనీయమైన విషయం. ప్రత్యేకంగా మనందరికీ తెలిసిన విషయం, భారత రాజ్యాంగం 3 విభాగాలుగా ఏర్పాటు చేసింది. ఫస్ట్ ఎస్టేట్ ఈజ్ లెజిస్లేచర్, సెకండ్ ఈజ్ ఎగ్జిక్యూటివ్, థర్డ్ ఈజ్ జ్యుడిషియల్ అండ్ ఫోర్త్ ఎస్టేట్ ఈజ్ ప్రెస్. సో అది రాజ్యాంగం ప్రకారం ఏర్పాటు అయిపోయినా దాన్ని వాచింగ్ డాగ్ చేయాల్సిన బాధ్యత ప్రెస్ అండ్ మీడియా మీద ఉంది. ఈరోజు న్యాయ వ్యవస్థ మీద పడ్డ న్యాయ వ్యవస్థకి సరైన సహకారాలు అందించకుండా ఉన్న అన్ని చట్టాల్లోనూ కోర్టులు పరిధించి తప్పించి సబ్ కలెక్టర్కి, డిప్యూటీ కలెక్టర్కి, ఎంఆర్ఓకి అప్పచెప్పడం జరుగుతుంది. వాళ్ళు ఏం చేస్తూ ఉంటారు? ఖచ్చితంగా మంత్రులు ఏం చెప్తారు, కలెక్టర్ ఏం చెప్తాడు, అఫీషియల్స్ ఏం చెప్తారు, వాళ్ళ ప్రకారం చేస్తూ ఉన్నారు. ఇవాళ అనేక చట్టాల్లో రేరా యాక్ట్ చూసాం, కోఆపరేటివ్ సొసైటీస్ యాక్ట్ చూసాం, చిట్ ఫండ్ యాక్ట్ చూసాం. ఇట్లా నెమ్మదిగా ప్రతి చట్టంలో కూడా కోర్టులు పరిధించి తప్పించి వాటిని డైరెక్ట్ గా ట్రిబ్యునల్స్ గా కానీ ఏదో పేరుతో వాటిని మార్పించి న్యాయ వ్యవస్థను దూరం చేస్తూ ఉన్నారు. తద్వారా ప్రజలకి అన్యాయం జరుగుతూ ఉంది. రాజ్యాంగం కల్పించిన హక్కుల్ని ప్రజలకు దూరం చేస్తూ ఉన్నారు. ప్రత్యేక ప్రతిపత్తి కలిగిన జ్యుడిషియల్ ఏర్పాటు చేసి వాటి సంఖ్యను పెంచి, జడ్జెస్ సంఖ్యను పెంచి కేసులు అత్యవసరంగా వెంటనే ఇమీడియట్ గా చేసే అవకాశాన్ని కానీ, వాటికి కావాల్సిన ఫండ్స్ కానీ, కనీసం జడ్జిలను అపాయింట్ చేయడం కానీ, ఉన్న జడ్జిల్ని కూడా అపాయింట్ చేయలేదు. ఒక జడ్జి అయితే కనుక ఆ రోజు అతను రిటైర్మెంట్ కూడా తెలుసు కాబట్టి ఆయన రిటైర్మెంట్ ముందే జడ్జిని రిక్రూట్ చేసుకుని ఆయనకి సంవత్సరం పాటు ట్రైనింగ్ ఇచ్చి, ఆ ట్రైనింగ్ అయిన తర్వాత బై ద డేట్ ఆయన సీట్లో ఉండేటట్టు చూడాల్సిన బాధ్యత ప్రభుత్వం మీద ఉంది. కనీసం ఆ పరిస్థితి వాళ్ళు లేదు. అనేక కోర్టులు ఖాళీగా ఉన్నాయి. ప్రమోషన్లు ఎప్పుడు ఇవ్వాలి ఏంటి అనేది కూడా బై ద డేట్ ఏ రోజు అయితే ఆ పోస్ట్ వేకెంట్ అవుతుందో ఆ రోజు పూర్తి చేయాల్సిన బాధ్యత ఉంది. ఉన్న జడ్జిలు పూర్తిగా పనిచేస్తేనే కానీ మనకి కేసులు ఇవాళ పెండింగ్ లో ఉన్నాయి, కొన్ని లక్షల పెండింగ్ లో ఉన్నాయి. కాబట్టి మేము ఆ కేసుని వేరే ట్రిబ్యునల్స్ ఏర్పాటు చేస్తామనే పేరుతోటి రకరకాల పేర్లు పెట్టేదానికి ఎన్సిఎల్టీ కానీ, బిల్డింగ్ ట్రిబ్యునల్ కానీ, అడ్మినిస్ట్రేటివ్ ట్రిబ్యునల్ కానీ ఇట్లా రకరకాలు పెట్టి చాలా ఇబ్బందులు పనిచేస్తా ఉన్నాం. ఉన్న స్టాఫ్ కి దాదాపు మనకి 2019లో హైకోర్టు ఏర్పాటు చేయడం జరిగింది. ఈనాటికి కూడా ఇంకా స్టాఫ్ కొడుతుంది, మనకి స్టెనోర్ కొడుతుంది. వాటి అపాయింట్ చేయకుండా జడ్జిలు ఏం చేయగలుగుతారు? ఒక్కొక్క జడ్జి 150 కేసులు, 200 కేసులు, 300 కేసులు చేసిన కూడా ఉన్నాయి మన హైకోర్టులోనే. కాబట్టి వాటిని మనం తగ్గించాల్సిన అవసరం ఉంది. ఎప్పుడైతే మనం ఈ ప్రత్యేక చట్టాలు చేసి వాటి నుంచి న్యాయ వ్యవస్థ నుంచి మనందరూ కూడా ఫిజికల్ గా కూడా పోరాడాల్సిన అవసరం ఉంది. న్యాయస్థానాల్లో కాకుండా బయట బయట కూడా మనం ఎమ్మెల్యేలు వచ్చి కొంత
మనకున్న హక్కుల్ని బాధ్యత మన మీద ఉంది. కనీసం కోర్టులు ఇవాళ అనేకమైన కారణాలు చెప్తా ఉన్నాయి. కంటెంప్ట్ ఆఫ్ కోర్టు కింద దాదాపు 1960 తర్వాత ఇవాళ దాకా నాకు తెలిసినంత వరకు ఏ ఒక్క వ్యక్తి కూడా కన్విక్షన్ పెండింగ్ లో ఉన్నాయి. అనేకమైన కేసుల్లో వాటి మీద విచారణ జరగడం కానీ ఐఏఎస్ లేదా ఇతర అధికారులు దానివల్ల చాలా అధికార దుర్వినియోగంతో పరిరక్షించాల్సిన బాధ్యత మనం కంటెంప్ట్ ఆఫ్ కోర్టు కింద ఈ అధికారులు చట్టాన్ని అమలు జరిపే అవకాశం ఉంటుంది. మనం కాపాడబో న్యాయ వ్యవస్థ కూడా. థ్యాంక్ యూ సార్.
Thank you so much on behalf of the Adv.R.Balaji Bar Association and Bar Council of India members, Sri Ramireddy garu also. I welcome you, sir. Thank you for arranging this seminar to the Vijay. Our senior member, Sri Chalsan Ajay Kumar, who is ex-president of Adv.R.Balaji Bar Bar Council of Andhra Pradesh. He has also cooperate for all arrangements. And Sri Chalsan Ajay Sunkar Rajendra Prasad, also previous ex-president of Adv.R.Balaji Bar Association, is a senior member of the bar. He is also given extend his cooperation. Yes, Mallesh Rao garu is also senior most member in the Bar Council of Andhra Pradesh. He has extended his cooperation to all the developments of the Adv.R.Balaji Bar Association. I special thanks to the principal Siddhartha Law College, Mr. Adv.R.Babu garu. He has given a maximum cooperation to success in this function. I once again thank you, all of you, the students of Law College, the faculty of the Siddhartha on the dais, Mr. Sittaru Nageshwara garu is also senior Bar Council member, who is ex-president of High Court Bar Association, and another Dwarkanath Reddy garu is also here. I welcome you, sir. I extend my thanks to the and other members also, Mr. Chidambaram garu, Mr. Narsingarao garu, Mr. Krishnamohan garu, and other additional district judges. I thank you one and all to giving me this opportunity. In fact, this great seminar for a particular purpose, the developments from time to time, and well experienced Justice Apple Sastai garu will explain. and more particularly this Krishna Chakravarti Garu is a very expert in electronic evidence. So he also shared with his experience to all of us. So it's a great privilege on Adv.R.Balaji Association along with this Siddhartha students. Once again, thank you all. Thank you.
Now it is my turn. The Justice Session Sai Justice Chakravarti Garu, the principal of the Law College, president of the Adv.R.Balaji Association, Sundar, Vice Chairman Rameswara, Bar Council of India member Ramaredi Garu, my colleague members in the Bar Council, the judicial officers, the advocate friends, students, the faculty. The Bar Council of Andhra Pradesh has been conducting seminars, trying to conduct and reach every district and instill inclination in the minds of the advocate community to take the importance of these continuous education programs. If somebody in the profession feels that he learn everything, nothing to learn, then he will become irrelevant. So therefore, we are always students of the law as long as we are in this profession. By this time, we are able to conduct 10 seminars in covering 9 districts. And apart from this, one day, first May, we are able to conduct a 3-day orientation program in Kerala University, where like a residential camp, where all the intensive orientation program, giving a thorough preparation in certain aspects, not only in the law, but also in other aspects like communication skills, drafting skills, and interacting with each other is very important, which is not happening in this profession. And Bar Council, with the cooperation of the various bar association, will be able to proceed with this continuous education program, and for the purpose for which it is intended to. And always I have been sharing my idea on the necessity and need of the establishing a permanent infrastructure like Advocates Academy. And within I am confident that with the cooperation of all the members of the Bar Council and this kind of program will be available on a continuous process. With these few words, I want to say and especially the law college, the principal of the law college for cooperating with us. This has been since long time we have been planning, but ultimately we are able to we are able to commence this program. Thank you very much. I Skila to give his brief message. Today's president
బార్ కౌన్సిల్కి. ఎందుకంటే గత 10 సంవత్సరాల నుండి అల్లు పెరగకుండా అన్ని ప్రోగ్రాంలకు హాజరుకుండా వచ్చే జస్టిస్ ఆకుల శేషయ్య గారు, వారి ప్రత్యేక జస్టిస్ చక్రవర్తి గారు, రెస్పెక్టెడ్ వైస్ గారు, మై కొలీగ్ మెంబర్ గారు, మల్లేశ్వర గారు, ప్రెసిడెంట్ ఆఫ్ ది బార్ అసోసియేషన్ బెజవాడ సుందర్ గారు, దివాకర్ బాబు గారు, రెస్పెక్టెడ్ జ్యుడిషియల్ ఆఫీసర్స్ అండ్ కృష్ణమోహన్.
సెమినార్ శ్రీ గంటా రామారావు గారు, ఆంధ్రప్రదేశ్ జస్టిస్ ఆకుల వెంకట శేషయ్య గారు, ఆంధ్రప్రదేశ్ జస్టిస్ చక్రవర్తి గారు, esteemed members of the Andhra Bar Council, రామజోగేశ్వరరావు గారు, బార్ కౌన్సిల్ ఆఫ్ ఇండియా, సుందర్ రాజేంద్ర ప్రసాద్ కుమార్ గారు, I extend warm, pleasant and hearty welcome on account of Siddhartha Academy. This is the developed Dotamba Siddhartha Law College and on my own account. We are really grateful to the Andhra Pradesh State Bar Council for bestowing the great honor, privilege on our college for organizing this wonderful seminar. For the reason that law on the text is always different from the law in action. So we always make an endeavor to match this gap. So in this direction, so when the Bar Council of AP State Bar Council made a proposal for organizing this wonderful seminar, we instantaneously agreed for the reason this kind of seminar will definitely give an insightful learning to our students as well as faculty. So with that perspective in mind, organizing this seminar, and I take this opportunity to express our immense sense of gratitude and profound thanks to the Bar Council of the AP State Bar Council for giving this wonderful opportunity for organizing this seminar. So as in the opening remarks, as Sundar Rajan Prasad has rightly said, that this profession always demands constant and continuous learning. As has said, the moment you stop learning, the moment you are deteriorating and decaying and dying. So with this perspective in mind, we are this seminar, and I am sure and certain that the presentations will be made by Honorable Justice Akul Venkateshwara Garu, Chakravarti Garu and Dutta Prasad Garu will be giving wonderful insight, inspiring, electrifying and erudite insights in the. And I once again take this opportunity to immensely thank the AP State Bar Council for giving this wonderful opportunity. Thank you very much, sir.
Thank you very much. But here is the cooperation act to rule. It would like we come up to this chair. I request the chief guest of this today's session,
President of this
a wonderful event. And the captain of Andhra Pradesh legal Sri Adv.R.Balaji, Sri President Adv.R.Bar Association, senior members of Adv.R.Bar Association, my heartfelt pranams to all the participants here. I am very happy to see a good number of law students here, especially girl students. For motivating them in such a manner, we should really appreciate the president of this reputed institution, the principal of this institution, Sri Adv.R.Balaji, and the management. I am very fortunate enough to be an integral part of this great event, great program today. At the outset, the organizers of this program, Andhra Pradesh Bar Council and Adv.R.Bar Association, they need lots and lots of appreciation from all of us. It's a known reality that Adv.R.Bar Association is a reservoir of prudent, dynamic, and well-behaved lawyers, and all of us know it has produced a number of legal luminaries. And all of you know that the only thing that multiplies on sharing is the knowledge. The motto of this event is share what you have, get what you want. That is the motto of this type of programs. And these are basically intended, as rightly said by Rama, intended for youngsters, future of our profession. I request all of you, especially youngsters, to make use of this wonderful event. And finally, I have no hesitation in saying that unless the bar is vibrant, competent, good and dynamic, we can't expect good judges also for this system. I have a lot of things to share with you in the first session. With the permission of the President, Sri Rama, shall I start the first session, sir? Of course, after taking coffee, us begin this session, first session of this event, by offering salutations to two versatile and great personalities of this country. One is Father of the Nation, Sri Mahatma Gandhi. Another is Bharat Ratna, Father and Author of the Constitution, Sri B.R. Ambedkar. As said by me, this type of programs are basically intended for the youngsters of our system, and they need to be conducted very often. That's what the Bar Council is also doing, so that there can be interaction and introspection, which are highly essential for our profession and the system at large. Dear friends, very often, very frequently, we come across one thing, and that is, everything should be done in accordance with the law. Everything should be done in accordance with law. What is meant by law? Is it defined anywhere? I request the youngsters to. Anybody from the youngsters? Especially from the students of this great institution. Please raise your voice. Please participate. No hesitation, absolutely. It is our family only. Yes, so please raise. Please indicate your name and say what you want to say. Emma?
I am a 4/5 LLB student. I would like to present Austin's definition regarding law. He says law is the command of sovereign and it is backed by sanctions.
That's all? Anybody? Any other student of this institution? Or the young members of the bar?
Rules and obligations that are due to be followed by the citizens of the country.
That's all. Any other participant? Sorry, please.
I'm not telling about anyone's definition. Law means land, A means air, W means water. Anyway, law is there is a rule and regulations which is very process.
Excellent, Emma. Let us give round of applause. Emma, of the Indian. Can you tell? Or will you tell? Thank you. Thank you, Amma. The reason why we offer salaries to Sri Bharat Ratna Ambedkar. Article 30. According to that provision of law, an act made by the Parliament or a state legislature, a rule or regulation, that is law. 13(3). Another doubt of mine is, can there be a law? Can there be a statute? Can there be a rule of regulation contrary to the provisions of the Constitution? Somebody is saying no. Why no? Yes. Somebody is saying no, sir. Please raise yes. Somebody has risen.
My name is Ramaya. Constitution itself is the master law.
Very good, sir.
Any law deviating or against the provisions of the Constitution are in ab initio void.
What is the provision of the Constitution which deals with it?
I cannot.
Same provision, Article 13 only. Article 13 mandates, specifically mandates, that the law inconsistent with or in derogation of the basic structure of the Constitution, that is Chapter 3 Fundamental Rights, is a void law. Void from the beginning. So any laws made by the legislature or Parliament should be subservient to the provisions of the Constitution only. They have no other goal. And another thing is, all of you know, laws are basically or broadly categorized into two. What are they? Yes, sir. Somebody has to raise and say yes. There are two categories broadly. What are they?
I am Ramakrishna.
Ramakrishna Garu.
Final year student of.
Very good. Shortly you are entering the profession. Right, sir.
So I would say it is the two parts of the law. One is substantive law, the other one is the procedural law.
Very good, sir. Excellent.
So the substantive law deals with the statutes and the provisions as per the statutes, while the procedural law deals with the procedure to realize those proofs given by those statutes.
Very good, excellent, sir. Substantive law deals with the rights and liabilities of the parties, as rightly said by Ramakrishna. Whereas procedural law deals with the mechanism and the procedure for enforcement of the rights and liabilities of the citizens. In this scintillating event and on this auspicious occasion, I have been asked to share my thoughts. I request all of you not to treat this as a lecture. Only basically intended for, as said by me, interactions in process. And Civil Procedure Code with special reference to interlocutory applications. All of you know, the Code of Civil Procedure 1908 regulates the procedure which needs to be adhered to in civil courts. Would anybody say when this CPC came into force? For the first time, 1908 is the year of legislation. from which date that law came into being? 1st September 1909, sir, you are correct. That is the reason why this institution is called a reputed and a renowned institution. All of you know, this Code of Civil Procedure has undergone a number of amendments and modifications so far. When the last amendment took place, anybody? Amma? Give that mic. Give that mic. Yes, Amma, please. 2002. 2002. From which date those amended provisions came into being?
They are substituted.
From which date, Amma? 17. The subject matter challenge only Honorable. Of course, there was Honorable Supreme Court. What is that decision? Association. Yes, Venkatesh is correct. Salem Bar Association case. Then how many sections are there in the case and how many are there? How many sections are there in the CPC right now? How many orders are there which regulate the procedure?
150.
150. Orders are there? 50 orders are there.
Are either expressly or implied.
Now let us go into implied exclusion and express exclusion. What is meant by express exclusion and what is implied exclusion? Would anybody? Provision of law says unless the jurisdiction is barred either impliedly or expressly. What is meant by express exclusion and what is meant by implied exclusion?
So insofar as express exclusion is concerned, there is a specific statute to that effect which deals on that particular matter and therefore that is covered as express exclusion.
What is implied? Yes, anybody? Any other friend? Yes, sir. Sir, Rameswar.
Sir, implied exclusion is the very, so as the definition said, it is by civil codes, the civil suit in civil code. And a criminal case would become an implied exclusion for a civil code.
Right. That's all? Yes, anybody? Any other? So according to section 9 of CPC, we can maintain all types of suits and the courts have jurisdiction to try them unless they are barred expressly or impliedly. Expressly means, supposing there is a special statute, you have come up to certain extent, sir. Karthik. Express means, supposing there is a special enactment is there and there is a provision under that enactment, expressly by way of a provision of law barring the jurisdiction of the civil code, that is called express exclusion of the jurisdiction. Then coming to implied exclusion. Supposing there is a special law covering that field, though there is no specific provision, if an effective mechanism is created in that, then it is called implied exclusion. అంటే ఆ స్పెషల్ లాలో ప్రొవిజన్ లేకపోయినా ఎఫెక్టివ్ మెకానిజం మాత్రం ఇస్తే అటువంటి పరిస్థితుల్లో ఇంప్లాయిడ్ ఎక్స్క్లూషన్ అప్లై అవుతుంది. దెన్ another section of law under CPC is section 10. Very often we come across this. Section 10. Emma? Amma Jasmine, which happened?
Res sub judice. Stay of suit.
Stay of suit. Which suit has to be stayed? Which suit has to be stayed under this provision of law?
ఆల్రెడీ కనుక కోర్టులో సూట్ రన్నింగ్ అది వేరే కోర్టులో మళ్ళీ ట్రయల్ పడదు.
ఏ సూట్ స్టే చేయాలమ్మా? ఫస్ట్ సూటా సెకండ్ సూటా? సెకండ్ సూట్. నాకు ఒక అనుమానం వచ్చిందమ్మా. ఆ అనుమానం ఏంటంటే ఫస్ట్ సూట్ ఈస్ ఇట్స్ ఎ సూట్ ఇంజెక్షన్ సింప్లిసిటీ. ఫస్ట్ సూట్ అమ్మా ఇంజెక్షన్ సూట్ మాత్రమే, పర్మనెంట్ ఇంజెక్షన్ అడిగారు దానిలో. సెకండ్ సూట్కి వచ్చేటప్పటికి ఇట్స్ ఎ కాంప్రహెన్సివ్ సూట్, సూట్ ఫర్ డిక్లరేషన్ ఆఫ్ టైటిల్ అండ్ ఇంజెక్షన్. విచ్ సూట్ హ్యాస్ టు బి స్టేడ్? ఈజ్ ఇట్ ద ఫస్ట్ సూట్ ఆర్ అకార్డింగ్ టు సెక్షన్ 10 సెకండ్ సూట్? Can the first suit be stayed by invoking the provisions of section 10 of the code? 10 says subsequent suit. Then how to resolve this issue? What is that you can? What is the remedy you are suggesting for? Anybody? Yes sir, somebody. Good. Good. Then let us go on to another provision of law, that is section 11 of the Act. 11, it is a very popular section. Section 11 of the code. What is it? Section 11? Emma? Res judicata. What is meant by res judicata? What is meant by res judicata? Would anybody say? English lo cheppalఅవసరం లేదమ్మా, తెలుగులోనే చెప్పండి. Sir, please. Mic out, sir.
Sir, matter already decided, need not to revoke it.
Matter already decided should not be revoked. So let us welcome Durga Prasad here, sir.
request Sri Durga Prasad to come out.
I want to be a spectator. Please continue.
Institution of the second suit on the same issues. That is bar. Is it so, sir? What are the objects of this provision of law? What exactly the object behind this provision of law?
Not to military party.
Yes, Amma. ఎవరో ఇది అంటున్నారు ఒక్కసారి చెప్పండి మళ్ళీ మైక్ ఇవ్వండి. There are 2 mics now.
So to avoid the multiplicity of the suits.
To avoid multiplicity of suits. Yes, sir.
Not to build the parties.
Not to
build the parties.
build the parties. Then
So reduce the burden on the judiciary system.
Reduce the burden of the judiciary system. Very excellent. Yes, sir. Yes. Any other opinion? In the interest of the state, there should be end to litigation by Venkatesh. Right. Amma.
Same party, same matter.
What's your good name, Amma?
My name is Neetu, sir.
Amma?
Neetu.
Right.
Same parties, same matter.
Same party, same matter. Right. Vika.
Sorry. Sir.
Right, sir. Yes,
sir.
Somebody said.
Sir, my name is Bangaraju. సార్ ఇదేంటంటే ప్రభుత్వానికి ప్రజలకి ఖర్చులు తగ్గించడానికి ఇబ్బంది పడుతున్నాం.
So these are all the objects behind this provision of law.
Yes, sir.
Save the valuable time of the court.
Save the valuable time of the court. Another view. Right, sir. All of you are correct. Practically you are correct. Ultimately, this safeguard this particular provision of law safeguards the litigant public from the onslaught of frivolous and vexatious litigation. And apart from that, as rightly said by Venkatesh, this gives finality to the litigation. Then, coming to sections 15 to 20, they tell about the place of institution of the suits. 33, all of you knows, deals with the judgments. Supposing you are aggrieved by a decree of trial court, what is your remedy? You are aggrieved by, but the party is aggrieved by a decree rendered by a trial court. What will you do? Suit is decreed, what the defendant has to do?
An aggrieved party can go to appeal.
Appeal. That is first appeal. That is appeal in appellate suit. Under which provision of law this has to be instituted?
96.
96. Read it. Article 41. Thank you, sir. First appeal, all of you know, is a right of appeal. Where the second appeal lies, first appeal is a matter of right, second appeal lies when there is, students, dear students, when there is substantial question of law. What is meant by substantial question of law? Is it a mere question of law or more than that? More than that. Then what is meant by substantial question of law? Not decided by the court. That is one version. Any other version from anybody? What is meant by substantial question of law? ప్రయత్నం చేయండి, పర్వాలేదు, తెలుగులో చెప్పండి. Sir, చెప్పండి సార్.
The law applied in the particular judgment, whether it is applicable to it or not, is to be verified. Is called substantial point of view.
Right, sir. Any other view? Yes, sir.
Trying to evaluate and understand the legislature objective on the provision, particular provision.
Right, sir.
In a detailed manner.
Thank you. Thank you, sir. Anybody?
Which affects the large number of people.
Amma.
Which affects the large number of people.
Substantial question of law is a question of law which affects a large number of people. Right. Any other version? Please participate. I request you to please interact. Be bold enough. A question, yes, sir, you are saying.
Sir, I am Shishidhar, sir.
Sir.
3/3 LLG. The substantial question of law is a question where it was not decided by earlier courts in anywhere and no precedent was there.
Thank you, sir. Thank you very much. Precisely, a question of law which substantially impacts or affects adjudication of issues is called substantial question of law. This is the essence of all the views. Then, there is one provision of law which bars second appeals after amendment to the CPC. There is one provision of law which came to be inserted by way of amendment in 2002. According to which second appeals are barred. What is that? That is correct. 100A. 100A is that provision of law, according to which wherever the value of the suit does not exceed 25,000, second appeal does not lie. Is it applicable to suits of all nature? All suits wherever the value does not exceed 25,000, their second appeals are barred? Or there is an exception to that? 100A. All suits are barred? Only one type of suits are barred. Only money suits are barred. Other suits, second appeal lies under 100. Another important provision of law is section 151 of the Code of Civil Procedure. ఇది మనకి తారక మంత్రం అండి. 151 అనేది. అమ్మా? Inherent powers of the court. అంటే inherent అంటే? What is meant by inherent? Inbuilt power. అంతేనమ్మా? Inbuilt power. What is the object behind this? Object is to meet the ends of justice. Wherever there is no specific provision under the code, this provision of law can be invoked by the courts. Supposing there is an alternative remedy, there is a specific provision under the code. In that contingency also, supposing an order is passed by the trial court, order is to be passed. Can you maintain an application under section 151? When there is a specific provision under the CPC, can you maintain an application under section 151 or not? No. When there is alternative remedy, you can't invoke the provisions of section 151 of CPC. Since we are dealing with the interlocutory applications today, let us focus on those applications now. In my view, if we treat the suit as a tree, its branches are interlocutory applications. Before going further, we should know what exactly the object of interlocutory applications. The object of interlocutory applications we should know first of all. Yes, anybody? Is there any object behind these interlocutory applications? Why not a mere suit? Why there should be interlocutory applications? Yes. Why should there be?
My name is Murthy, sir. Not to prejudice the parties while the suit is in pending. That's the main reason object of it.
To avoid the prejudice to the parties pending litigation.
Pending litigation.
Right, sir. Yes, sir. You are saying something, sir. Protection of subject matter pending disposal of the suit. Right. Thank you, sir. Thank you. Yes, sir. End friend.
To get the interim relief, sir.
To get the
interim relief.
interim relief. Very good. Any other? Any other answers?
It would take a lot of time for the disposal of a suit when it comes to litigation. Therefore, if a party wants interim relief within the disposal of that suit, he can seek through an interlocutory application.
Thank you, sir. Thank you very much. Any other? Because we are focusing today on interlocutory applications, let us have a broad idea about it. The object of interlocutory applications is, and the orders passed thereon, is the preservation of the rights as rightly said by our friend, and property pending litigation and pending adjudication. Because the party ultimately succeeding in the suit should not be put to any prejudice. I would like to place before you certain important interlocutory applications which we come across very often in our day-to-day adjudicatory process. Today I am confining myself only to 5 types of applications. First application is Order 1, Rule 10. What does it say? What does Order 1, Rule 10 say? Yes, sir. We are starting from 1. Yes, sir, please. Mic on, sir. It deals with what, sir?
Impleading of the necessary parties, proper and necessary parties.
Impleading of proper and necessary parties. Then, yes, sir, anybody else? Amma, from your side.
Suit in the name of wrong plaintiff, sir.
Mic is.
Suit in the name of wrong plaintiff, sir.
Suit in the name of wrong plaintiff. Right. Then. Yes. Any other? This provision of law deals with the power of the court either to strike out or anti parties. Either to strike out or to anti parties. The condition precedent is proper and necessary parties should alone be allowed to come on record according to this provision of law. Another contingency is the presence of such party or individuals should be necessary for complete adjudication of all the issues in the suit. Then what is the object of this provision of law? What is the object behind this provision of law? Is there any special object? Order 1, Rule 10. Why somebody should come on record? to avoid multiplicity of litigation. You're correct. So would you please note down the judgment so that they will be helpful at the youngsters. 1999 Supreme Court 976 AR 1999 Supreme Court 976. Then 1995 3 SEC 147 AR 1958 Supreme Court 886. Then 2012 third volume Andhra Legal Decisions 128 and 320. 2005 6 Supreme Court cases 733. 2005 Supreme Court cases 733. In fact, I came across one difficulty when I was working in Composite High Court. Before that, I would like to say one thing. In a suit for specific performance of contract of sale, in a given case, it is a suit for specific performance of contract of sale or agreement of sale. Whether a third party who is claiming independent right over the property, can he be permitted to come on record? In a suit for specific performance, a third party, can he come on record claiming right over the property independent of the rights in the suit? Can he be? Specific performance suit law, third parties record में कर रावचा.
Yes, sir. Learned advocate. Somebody is saying yes. Yes, sir. He can file claim petition. Claim petition. We are dealing with Order 1, Rule 10. Can there be an application by such individual under the provisions of Order 1, Rule 10? Can he maintain an application or she can maintain an application under Order 1, Rule 10? Suit is pending, sir. Okay. And he claims right over the property independent of the rights in the parties to the suit. Yeah. Right, sir. Thank you. Yes, anybody else? Specific performance suit law. Yes, sir. You are saying, sir.
So my name is Padmanabhan, sir.
Yes, sir, Padmanabhan.
So being a subsequent purchaser of the property in a suit for specific performance under Section 19 of the Statutory Relief Act, he has to prove that he is a bona fide purchaser. He has to come on record and Order 1, Rule 10.
So, this is permissible or not permissible?
Permissible, sir.
Permissible. But there is one Supreme Court judgment on this. A person claiming a right, yes, you are correct. If there is a claim independent of the right, then he cannot be. Same problem I came across, sir. It was also, please be seated. It was also a suit for specific performance. An application was moved by a third party saying that he purchased the property from the defendant in the suit, of course pending litigation, bona fidely. Then the trial court dismissed the application. Ultimately the issue landed before the High Court by way of a revision under 227. In that case, as rightly said by him, the defendant, he remained ex parte. Probably the case was argued by Chalmaragan Anukunta. Correctly? Defendant remained ex parte. This judgment was sought to be pressed into service, saying that he cannot be implemented at all. I took that view. What the view you have expressed, sir, I have taken that view only. I allowed the CRP, implemented the party. Sir, in one case, a peculiar situation cropped up. Parties aggrieved by an order filed an appeal before the appellate court, impleading the judge who passed the order by name. What will you do? But there can be a direction to the court if it is subordinate. There can be a request also. That practice was deprecated by the Honorable Supreme Court. Please make a note of this. 1999, two Supreme Court cases, 577. Following that, there is one judgment of the Composite High Court by a division bench. 2014, 3 Andhra Law Times 590. It cannot be. That is 2005, 5th volume, Andhra Law Times 705. But one exception is there. LRs, if they want, they can come on record. On their own, they can come on record, sir. Another situation is whether a person who supports the case of the plaintiff, can he be permitted to come on record as defendant? He totally supports the case of the plaintiff. He wants to come on record. Can he be permitted under Adv.R.Balaji Rule 10? No, cannot be permitted. 2013, 1st volume, Andhra Law Times 96. Some participant must have come across the land acquisition cases. Supposing an individual is aggrieved by an award passed by the land acquisition officer, he has to ask for the reference under section 18 of the Act. In a given case, he did not avail that opportunity, statutory benefit. But in some other procedures initiated by somebody else under section 18 of the Act, he wants to come on record. Can he be permitted? In the reference under section 18 of the Land Acquisition Act, Adv.R.Balaji Rule 10 application, is it permissible? No, it is not permissible. That is 2011 third volume, Andhra Law Times 617. So this is broadly about Order 1 Rule 10. Now let us switch over to appointment of commissioners. Which provision of law deals with this? The provisions of law which deal with the appointment of commissioners. Order 26, you are correct. What is the substantive provision of law? Section 75. Then for what purposes commissioners can be appointed? For what purposes commissioners can be appointed? What are the purposes? Sir, please raise and say whatever you want to say, sir.
Sir, to examine witnesses, number 1. Number 2, to make partition. Number 2, check on any accounts for that matter. And there is one more under section 75, one more objective.
Thank you, sir. Excellent. You may get so many doubts while dealing with these applications. Can a commission be appointed? Collection of for collection of evidence, whether appointment of commissioner is permissible? No. Appointment of commissioner is impermissible for collection of evidence. And can be a commissioner in possession of the property? Cannot be. To find out who is in possession of the property, ఇప్పుడు ప్రాపర్టీలో ఎవరున్నారు అనేది తెలుసుకోవడానికి కమిషనర్ మనం అపాయింట్ చేయొచ్చా? ఇంకోటి పని ఏంటమ్మా? ఇట్ ఇస్ లెఫ్ట్ టు ది కోర్ట్ కమిషనర్. నో. Another problem which we come across very often is whether a second commissioner can be appointed for the same purpose. Yes, Amma? You are sure? Under what circumstances? When the court is not satisfied with the first commissioner's report, the commissioner can be appointed for the same. Yes, sir, you are saying something. Can be appointed for the same purpose. Unless is the there can never be appointment of the second commissioner. 2017, 5th volume, 5 andi. Execution, whether commissioner can be appointed. In EP, commissioner can be appointed. There is one provision of law which deals with that. On the 26th rule, 18A, a new insertion now. Then next important provision of law is Order 38 Rule 5. It's a very harsh remedy. Order 38 Rule 5. Anybody? Attachment? What is the object behind this? Is there any special object behind this provision of law? Yes, sir. Same thing, preservation of rights, alienation of property, to maintain the status quo. Same thing, that is the... You may get another doubt. That is, whether the court has power to order attachment of property situated outside its jurisdiction. Is it permissible? Supposing property is situated in Guntur, court is situated in Vijayawada. Whether Vijayawada court can attach the property, though it is beyond the jurisdiction of the court. Yes, sir. There is specific provision for that, sir. Transfer, correct. That is called precept. Section 136. That is AR 1961, leading case, AR 1961 AP. It's a division bench judgment, 96 4 ALD 1137. Another thing is, supposing a property is attached before judgment, suit is ultimately decreed. Is there any necessity to attach the property once again in EP? Is there necessity, sir? Once again to attach the property, is there any necessity? There is an order of attachment pending suit. The provision of law is not necessary. Rule 11 of Order 38. 3811. 3811. Supposing there is interim attachment. Attachment before judgment is there. Suit is dismissed for default, unfortunately. An application is moved to get the suit revived, to set aside the dismissal order. And that application is also allowed, setting aside the dismissal order. Suit is restored to file. Does it amount to automatic revival of the attachment order? Somebody is saying, fresh and recommended? Yes, sir. Fresh attachment should be asked. It automatically does not get revived. That is Rule 11A2 of Order 38. 11A2. But only one thing is, while ordering attachment, reasons are to be given. Reasons should be recorded by the court. Another aspect is, in a mortgage suit, can we ask for attachment? Mortgage itself is a charge. Is there a necessity to ask for attachment once again before judgment? Please make a note of this. 2006-3 Andhra Law Times 190. 2006 3 ALT 190. Next important provision of law is Order 39. That is Order 39. You come across very often, day to day. Emma? Injunction, temporary injunctions. You are correct, sir. Temporary injunctions. You hear that there should be presence of 3 indispensable ingredients. What are they? From the youngsters? Anybody? The condition precedent is there should be prima facie case, balance of convenience, irreparable loss to the person applying for. Supposing an injunction application is filed, injunction is granted or refused. What is the remedy open for the aggrieved party? Is it revision under Article 227 or 115 or an appeal? Anybody? Is it an appealable order or a revisable order? Under? It is an appealable order under. As per which provision of law it is appealable? Order 43. Kadama? Order 43. 43. Then, an argument was advanced before the Honorable High Court in a given case. An injunction application was filed in a particular suit. Court granted status quo order. It is neither an injunction nor a refusal to grant injunction. It is a status quo order. What is the remedy? Injunction orders are appealable. Refusal also is appealable. But peculiarly, it is a status quo order. It is neither an injunction nor a refusal to grant injunction. What is the remedy? Is there any remedy or no remedy at all, or Article 227 only? No. Still it is appealable. Appealable only. Supposing an order of injunction is violated, what is the remedy? Order of injunction is violated, willfully disobeyed. What is the remedy for the aggrieved? Yes, sir. Somebody is saying. ఒక్కసారి మైక్లో చెప్పండి సార్.
An interlocutor application has to be filed under Order 39 Rule 2A for the disobedience of the orders.
Then what is the remedy? What is the relief which can be granted by the court?
Imprisonment, civil imprisonment and the attachment of the property.
Attachment of property
and civil imprisonment.
Civil imprisonment. You are correct, sir. Thank you very much. Is there any time limit for jail? Is it 1 month or
30 days?
30 days or 3 months?
I'm sorry.
3 months.
Correct, not exceeding 3 months. You are correct, sir. Another issue is whether an ex parte injunction order can be granted against the government, whether it can be granted against the government or there is a statutory prohibition. Yes, sir? Cannot be granted. Why? Supposing there is imminent urgency, what should be done? What is the remedy? Person is remediless. Subsection 2 of section 80 bars it. 2017 17(5) ALD 174. Another thing is there any time limit for disposal of the injunction applications? Supposing an injunction application is moved today, is there any time limit for disposal of the application by the courts? When injunction is granted ex parte. When an injunction is granted ex parte, is there any time stipulation under the CPC for disposal of the main application for injunction? It is an obligation on the court. That is 3A, 30 days. 30 days it has to be. Then, last but not least, Order 40 Rule 1. Order 40 Rule 1. This deals with the appointment of receivers. What is the object behind this provision of law? Is there any special object behind this provision of law? Order 40 Rule 1. To preserve, to protect and manage the property pending litigation and determination of rights of the parties ultimately. There is one leading judgment on this. Would anybody? There is one leading judgment rendered by Madras High Court in 1955. Rather, that was the first judgment in an elaborate manner on the issue. Order 40 Rule 1. AR 1955 Madras 430. AR 1955 Madras 430. And the Madras High Court laid down 5 guidelines for appointment of receivers. Those guidelines are popularly called Panch Sadachar. You are correct, sir. And of course, this is one of the harshest remedies. But who should be appointed as a receiver? Anybody can be appointed? Anybody can be appointed as a receiver? Yes, sir? Panel of advocates. Yes, anybody? Who does not have any interest in the property? Then, an independent, impartial, totally disinterested person alone should be appointed as a receiver. Another doubt is whether this remedy is available exclusively to the plaintiff. Plaintiff matrame application pettocha. Is there any bar for the defendant to apply? Defendant as well can make an application. AR 2003 Calcutta 178. Please make a note of these judgments on this. AR 1997 Supreme Court, AR 1997 Supreme Court 164 and 173, 1994 6 SCC 545, 1994 6 SCC. This is broadly about the interlocutory applications, certain interlocutory applications. Finally, I would like to conclude this session with the great words of the great saint of this country, Vivekananda. He said, I quote, లక్ష్యం కోసం అలుపెరుగుక శ్రమిస్తుంటే నేడు కాకపోయినా రేపైనా విజయం సాధ్యమవుతుంది. జై హింద్, జై ఆంధ్రప్రదేశ్. థ్యాంక్ యూ వెరీ మచ్.
చేతిలో పెట్టినట్టుగా అండ్ గివెన్ టు us. ఇంకా ఇది అరటిపండు అలవడం కాదు, సిపిసి కాంప్లికేటెడ్ పనసపండు లాంటిది. దాన్ని కూడా అరటిపండు ఒలిసి మనకి తనలు మన చేతిలో పెట్టారు. థ్యాంక్ యూ వెరీ మచ్. ది బిజీ షెడ్యూల్ has to go to the High Court and attend that National Lok Adalat, and I request my colleagues, senior colleagues in the Bar and Krishna Mohan, Association Srinivas Rao and Secretary Sridhar to felicitate the chief guest of this. time is very short. Now I request Justice Durga Prasad garu to come on to the. I request Vice President Bejwada Bar Association to escort Madam Justice Durga Prasad garu. I request Mr. Sridhar, Secretary, Bejwada Bar Association, to present sapling to Justice Durga Prasad garu. Now the interesting session, presentation on admissions, relevancy of admissions and admissions in the trial by Justice Durga Prasad garu. In small modification of the original program, presentation. Therefore, we will continue this session and break for lunch. And third session we will have after post lunch session. We will have. We will get more dividends. Therefore, get every possible thing out of this program. And the third session is Justice Chakravarti garu. That will be the after. And therefore, I request full attention to these two sessions so that in our day-to-day practice, both these sessions will be more useful. This is Durga Prasad garu, like the first session, he will be conducting thorough research and analyze and give us the best, present in the best possible manner about the admissions and relevancy of admissions and confusions in the trial, because every day most of you practicing advocates and prospective advocates who are going to join the profession will be guided by these important aspects relating to the admissions and confessions in the process of conducting the trial. Justice Justice Durga Prasad garu to present on the topic relevancy of admissions and conventions in the trial.
Good morning, rather good afternoon to one and all. Chairman of the Bar Council, how much time I may take and complete within time? No constraints. Okay. Chakravarti. Land advocates and learning advocates, the law students. Today the assigned topic to me is the admissions and confessions. The admissions and confessions are the two important facets of Evidence Act, which we will find in the chapter 2, the relevancy of facts. Because there are law students are also appearing in this session, which I was told, I can only give a thumbnail sketch of what the admissions and what the confessions and what is their relevancy in civil and criminal cases. Okay? You may question me, or rather you can yourself question, why the admissions and confessions which are relevant in civil and criminal suits, criminal cases, are couched in Evidence Act. Because we will find them in relevancy of facts chapter from section 17 to 30. Is not it? Why then they have been placed or located in the Evidence Act instead of being placed in Criminal Procedure Code or Civil Procedure Code? Have you ever thought of it? Any answer? The previous session went on lively. I also witnessed most of the students as well as advocates were in a participant mood. Let us continue with it. What might be the reason the admissions and confessions are placed in the Evidence Act rather than in the procedural courts of civil or criminal? Any of you, please? If not, let me explain you. The evidence, the admissions and confessions are taken as, almost taken as a piece of evidence. After all, an admission is a statement. After all, a confession is a statement. Therefore, the admissibility of them in a civil or criminal case should be tested on the anvil of the Evidence Act. The evidence definition under section 3, you know, is a statement, an oral statement permitted by the court to be made by a party, which is a oral evidence, a document permitted by the court, both in the form of physical document and electronic document. That is documentary evidence. So also, an admission is taken almost, if you peruse the entire Evidence Act, is taken as one type of evidence, a piece of evidence tested on the admissibility aspect. Therefore, the legislators thought it fit to couch the chapter of admissions and confessions in the Evidence Act. Okay? Before discussing the admissions, their relevancy, the confessions, their relevancy, I think it is better for us to have a conceptual clearance on
some of the relevant terminology used in the Evidence Act. It will be easy, particularly for the law students, to understand what I want to discuss with you on the aspect of admissions and confessions. Fact and issue, relevant fact, these three terminologies are very much important because they will be reiterated in the admissions and confessions chapter. So what is a fact? Any of you? Which has been explained in section 3 of the Evidence Act. What is a fact? Any of you please? Even advocates also. Even High Court advocates also. Pardon? Take the help of mic.
Hello. Fact is.
Yes, quick please. We are Ramarao is cruel to me. He is not providing much time. Yes, please.
The fact is anything and relation of thing and which is capable of pursuit of the senses.
Can be capable of perceiving
of senses.
Senses. Very good. It is a partial answer. Will you complete it?
That means
anything which can be perceived by senses is not true, but that's not all about that. Something more is also there.
Anything and relation of things.
We will give you.
That means and includes anything, the state of things, the relation of things, which can be perceived by the senses, and any mental condition of which anybody is conscious.
Very good. It completes or supplements it. One part of the fact is, or one facet of the fact is, which can be perceived through the senses. I see, I hear, I talk through my senses, which you can perceive through your senses. This is a fact. And also mental cognition, not only the help of the five senses. He is good, he is bad, he is honest. These things cannot be perceived by the senses, but can be by mental cognition after considering so many facts. So fact is nothing but which can be perceived through the senses as well as by mental cognition by using our brain. Okay? But don't be mistaken that, at least so far as Evidence Act and law is concerned, fact is not truth. We commonly use both are complementary and supplementary terms. Fact and truth anukuntam. Fact is not always truth. Fact is only one thing. That's all. Fact may be a truth, fact may be a false also in a given situation. So this conceptual clearance is necessary. Fact and నేను చెప్తున్నాను fact అది generally we will talk, but that is not correct in law always. A fact is only a statement, that's all. It can be perceived by senses. Okay, this is what is fact in issue. Fact we could understand quickly. Fact in issue. What could be the fact in issue? Is any of you? You the mic please, we are not able to. Yes, fact and issue.
Fact and issue means that includes any fact from which.
Ladies first, ladies first.
Okay, Mizoram and Nagaland, there is a 0% representation of ladies, and here also we have the 0%, that is different area. Fact and issue means any fact from which, either by itself or in connection with the other facts, the existence, non-existence, nature and extent of any right, liability, disability, accepted or denied in any suit or in any criminal proceeding.
That is the definition. In real terms, what it is. Yes, exactly. That is the definition, no doubt. Please don't laugh, that is the definition. But what does it mean in real terms, madam?
The issue between the parties.
Of about what?
Subject matter. That is, whether the cruelty existed or not, or whether it existed registered or not, or whether the title belongs to A or B, the subject matter between the parties, which is in dispute.
Okay. I will refine it. Yes, a fact in issue is a singular fact or a bunch of facts from out of which the existence, non-existence nature of a right, liability or disability either propounded by one party and dismissed by other party or opposed by other party, a combination of which we can and that can follow. That means, in simpler terms, in civil proceedings, a fact in issue is nothing but an issue. That is the disputed fact. A claims that B executed a pro note and took loan and did not return, therefore I am entitled to a decree for that amount. This is a fact in issue, and B denies it to, and this is also denies the very execution of the pro note. This is another fact in issue, both of which coincides it together, says that whether B has executed a pro note or not is the issue for trial before the civil court, isn't it? This is what fact in issue. In criminal cases are concerned, the fact in issue is nothing but a charge, criminal charge against an accused, in simpler terms. So I have learnt about fact in issue. Then comes another important facet, that is relevant fact. What is this relevant fact about? Any of you please? What is the relevant fact?
The adjective clause of a fact.
Pardon?
The adjective clause of a fact. Adjective clause of a fact. That which qualifies the fact.
Will you more elaborate to in terms of Evidence Act, relevant fact?
That means it qualifies the fact.
Qualifies the fact in what sense?
It means it supports the, which raises the issue, and it sometimes gives you a wide application for the finding navigation of the truth. Supports the fact and navigating the truth. That's called to be said to be relevancy in the fact.
What is the qualification for a fact to become a relevant fact? What is the essential qualification for a fact to be called as a relevant fact?
It has to support the factors.
In legal parlance, okay. To some extent, the answer is correct, but to make it a fullness, a fact is said to be relevant. A fact is said to be relevant to another fact or fact in issue if both the facts are connected together in any of the manner provided by the provisions of the Relevancy of Facts chapter. Relevancy of Facts chapter has consisting of 5 to 55 sections, isn't it? So a fact is said to be relevant with another fact if both are connected in such a manner that in any one of the manners provided under section 5 to 55, I will clarify it. For example, section 6 is there. It teaches us res gestae. A fact which is not a fact in issue, it says so. I will explain. A fact is not a fact in issue, but it forms part of the same transaction, which is relevant. That is what this section says. In other words, it is called as a res gestae. That means that part of the transaction, that part of the worldly happening, they call it. So, a fact which is not a fact in issue, but it is so forming part of the same transaction of the fact in issue, is relevant. Means how? Let us take an example. A girl was raped in a secluded place by the culprit. She immediately comes to home weeping and explains the narration to her mother. Isn't it? Her mother and father goes to police station and makes a report, gives a FIR. Here, Of course, mother is a lodger of the report. Her evidence is admissible. But with regard to the narration of the incident, whether her evidence is admissible is the question. After all, she is only a third party. Her evidence is only a hearsay evidence. The golden rule is evidence must be positive and primary. Who says that I saw, he only has to speak. In the presence of girl's evidence, mother's evidence is admissible. Yes, it is admissible in the context of the res gestae principle because the girl immediately after the incident has come and in a natural course reported to the mother. The reporting to mother is one fact. Occurrence of the incident is another fact. Both are interluded by a very short time. The proximity of time lapse is so close that this secondary fact has become a part of and parcel of the main incident. There is no much time lag so as to make some more additions to the real fact while giving the FIR, isn't it? So a fact which is not a fact and issue, though not a fact and issue, but forming part of the same transaction, the second fact can be called as a relevant fact because it forms part of the same transaction. Her mother's evidence is admissible in evidence in the context of res gestae principle. This is what we call. So now again go to the relevant fact. The second fact is generally not relevant, but it became relevant because the occurrence fact and mother's narration fact, two facts are intertwined together because of section 6. Understood? So relevant fact means two facts are connected with each other in such a manner that through any one of the provisions of section 5 to 55. One more example, I will make it clear and we will proceed further. For example, a fact is not a fact in issue. A fact is not a fact in issue, but it explains the motive. It explains the motive or conduct of a party to a proceedings. Then it is also a relevant fact. It is so stated under section 8 of the Evidence Act. Motive or conduct of the party, you will find in the Evidence Act that immediately after the incident of the crime, the suspect has fled away, absconded. Generally, that fact is not relevant to the main fact and issue. Fact and issue is whether that particular person has committed the offense or not. His fleeing or his absconding may not be relevant in the natural course, but it may show his conduct. His conduct in fleeing caused a doubt on him, but that alone is not sufficient to punishment against him. So now you may be clear that how two facts can be said to be relevant with each other. They must be connected in such a manner that through any of the provisions under 5 to 55. So friends, we have seen some of the important terms: fact, relevant fact, fact and issue. Now we'll go to the admissions and confessions, because these terms will be repeatedly used in section 17 to 30. Admission from 17 to 23. Confessions are dealt with under 24 onwards. What is an admission of problem? Any of you please? What is an admission? Pardon? Accepting his part of the liability. Always accepting the part of liability will amount to admission or any other thing in the broader sense.
Admission general concept is an admission the truth of a statement, truth of a fact. Yes,
You have executed promote. Yes, I have executed. You are admitting or agreeing the truth of this statement given by other side. It may be sometimes going against your interest, or it may not go against your interest. But generally, admissions so as to admit that fact which go against the maker of that statement, against the interest of that maker. This is what section 17 to 23 speaks of. Admission is a statement from which an inference can be drawn with regard to a fact issue. Simply stating, admission is a statement from which an inference can be drawn with regard to the fact issue. That means, if a person admits it with regard to the fact issue, some inference we can draw. In the previous example I have given, the allegation is that, or the government is that he has executed, promoted and borrowed the amount. Plaintiff files the suit. B admits the execution of promote and borrowing the suit amount, but only seeks per installment decree. Here, the admission is drawing or allowing the court to draw an inference that he has borrowed the amount because of his admission. And section 58 of the Evidence Act says that an admitted fact need not be proved, isn't it? Therefore, the court need not direct the plaintiff there to go for trial and prove his statement because that fact has been admitted by the defendant. So, admission is a statement which allows the court, which permits the court to draw an inference with reference to the fact issue. This is what simply the admission general meaning is. Another important aspect is, since an admission is a very important facet and admission excludes the proof under section 58, in civil procedure code, a particular chapter or particular order is earmarked, isn't it, to deal with the admissions. What is that order? Any of you? Order 12, very good. Order 12 has been incorporated in Civil Procedure Code, particularly to deal with the admissions in civil matters. What it tells is, after pleadings are over, any party can give a notice to other side referring to important pleadings and inviting others' response, whether you are admitting these facts or not, propounded by me. If other party admits it, the court may dispense with the proof. Not only that, one party may give notice with regard to certain documents which he rely upon and ask the other party to give his response, whether you are admitting the genuinity of those documents. If other party responds positively, saying that I am not disputing, the court may again say that you need not prove those documents. Isn't that it? This object behind incorporating Order 12 is to save the valuable time of the court, so that admitted facts need not be proved, admitted documents need not be proved, only those facts which were disputed can only be proved by the other side. This is the importance of Order 12 under the caption, under the heading admissions. Okay? Now, in the admissions arena, we will have section 19 to 23. They will deal with how the admissions are relevant, whose admissions are relevant, whether the admissions made by parties alone are relevant, or admissions made by the third parties and strangers are also relevant. These are all dealt with under section 19 to 23. Okay? Section 18 to 23. Just we will quickly peruse and go to the confessions. Before that, I must tell, an admission and confession you have understood. Admission is agreeing with the truth of a fact, generally. Confession is, of course, is admission of guilt of that person in a criminal case. If we view in that sense, an admission is the genus. Genus means a large trunk with like a tree. Confession is only species of it, means one branch of it. That is why it is called as all confessions are admissions, but all admissions are not confessions. Understood? All confessions, because they originate from the general branch of admissions. Confession is admitting the guilt in a criminal case. But admission is much wider. It is not only admission of guilt in a criminal case, admission in civil matters also, in other matters also. Therefore, admission is generally called as a genus, and confession is called as a species of that genus. Okay? Then we will discuss, as I told, whose admissions are relevant, to what extent they are relevant, whether the stranger's admissions are relevant and binding against the party to the proceedings. We will quickly look into section 18 generally says that the statements of the parties, the statements of their agents, the statements of their representatives, and these are generally admissible in evidence. If I have in a suit my what you call agent, general power of attorney or special power of attorney, his evidence is admissible. Then my representative, same fact. If at all he makes any adverse statement against my interest, that will be binding on me so far as he continues to be my agent. That is what section 8 says, that it is admissible in evidence. Admissible in evidence. Not only that, the statement of a person is also admissible. I will clarify with one example. A mortgage deed has been executed in favor of two mortgagees. One mortgagee filed a suit against the mortgagor for realization of the amount, and because the co-mortgagee has not plaintiff, he showed him as a defendant. Then the defendant takes the plea that I never executed any mortgage deed. It is the other co-mortgagee was examined by the defendant. He admits that he has not executed any mortgage deed in our favor. Then this statement of the co-mortgagee is admissible against the other person. Of course, the other person, the plaintiff may prove that by taking money or for other extraneous reasons he has spoken false. That is a different aspect. But the admission made by a co-mortgagee, because he is having substantial interest in the subject matter, it will be admissible in evidence as an admission. But admissions, you know that they are not conclusive proofs. The person who is adversely affected may establish that the admission is not a genuine admission. That's a different aspect. So section 18 says that admissions of agents, representatives, as well as the persons who are having interest in the subject matter are admissible. For your comprehension, this is what held in AR 2015 Patna, page 202, Chandradeep Sahu versus Lal Das Sahu. The very same fact has been discussed by the Patna High Court. In more or less section 19 also reiterates the same fact. A person is having some interest in the subject matter, though he is not a party to the proceedings. Though he is not a party, that means he is a stranger to the suit. His admission is also sometimes admissible as an admission. I will clarify. Section 19 and 18 difference is, 18 says that the admissions of the agents, representatives and persons having interest are admissible. They are parties to the proceedings. Sometimes the admissions of third parties or strangers will also be admissible. In what context is, suppose A files a suit against the Gram Panchayat, claiming that the particular strip of the land running in front of his house is a public rasta through which he has a right of access, and Gram Panchayat is trying to efface it, close it, then he will have to suffer a lot. Therefore, for a declaration that it is a public rasta. Of course, Gram Panchayat denies it, saying that it is not a public rasta, it is a private property of the Gram Panchayat. It can be put in use in any manner. In this tussle, the neighbor of the plaintiff is examined by the Gram Panchayat to speak that it is never or it was never a public rasta, and all the inhabitants in that vicinity have an alternative rasta to walk in, and this is Gram Panchayat's property. This piece of evidence, which is an admission made by a stranger, no doubt, but his interest is also involved in the property. Suppose if he files a suit in future claiming it as a public rasta, his previous admission will go against him. Understood? Therefore, though he is a stranger in the present suit, because he is having some interest in the subject property, his admission is also admissible under section 19 of the Evidence Act. Understood? This is how we will come across whose admissions are admissible in evidence. For your comprehension, you may know it's a very old judgment, but it is a full-bench judgment. That is what 1913, volume 25, MLJ Madras Law Journal, page 329. Appavu Chettiar versus Nanjappa Gaundan. In this, the Madras full bench has dealt with how a third party's admission is binding against one of the parties. That third party is also having some interest in the subject matter. Then his admission may also be taken and considered by the court as an admission. So this is the way in which the admissions can be taken in civil proceedings. Admissions of the parties, agents and representatives, admissions of the strangers can also be taken into consideration. Then we will also come across in this process, section 21 is also a very important one in the realm of admissions. An admission can always be against the maker's interest, then only it can be taken as an admission, but not in his favor. Understood? As put it by one of the life friends, an admission must always be against the maker's interest, but not in favor of maker's benefit. That can never be called as an admission. For example, A files a suit against B for realization of the money on the strength of some noting in his own diary stating that B is liable to pay me money, he owed money. Understood? The plaintiff himself maintained a diary where he maintains that recorded that B owes money. This, can it be called as an admission? It can never be. But of course, under section 32 of the Evidence Act, in usual and regular course of business transactions, if a transaction is recorded in accounts, that may be taken as a piece of evidence. That is not the case here. A simply writes that B owes money in his diary, except that he doesn't have any other record. He claims that it is an admission. Please admit in evidence, I recorded in my diary that he owes money. No, it cannot be called as an admission because it is not against his interest, rather it serves his purpose. Therefore, such type of statements cannot be called as admissions. This is the gist of 21. Of course, section 21 has a very prominent exception that you must carefully note down. It will come handy by dealing with criminal cases. An admission made for his own benefit also sometimes admissible. That is under section 32. 32, isn't it? Section 32 of Evidence Act. A person speaks of with regard to the cause of his death or the transaction in which he is injured. This is for his benefit, to show that how he was injured. He is not making an admission against his own self, but he is explaining the particulars or circumstances, how he received injuries or how he is put to death or almost in a death stage. Then section 32 says that it is an exception to section 21. Though it is for his benefit, it is admissible. The famous case, most of you might be knowing, it has propounded the admissibility of that evidence under section 32 as an exception to 21 is, what is that famous case? Any of you? I will be happy to know. Very good. Pakala Narayana Swami versus Emperor. Some of us, if you want, they can note down AR 39, 1939 PC Privy Council page 47, wherein it has been explained the relevancy of the statement given by the deceased before he leaves for another town, that is Berhampur. He was going from somewhere in West Godavari to Berhampur to receive the money from the accused. They owe him money. Before leaving, he states that I am going, they called me to pay that money. I am going to Berhampur to receive the money. Told to his wife, but he did not return. The fate was such that his dead body was found cut into 7 pieces and found in a trunk. The police, railway police in Berhampur, they recovered that dead body and then they investigated and ultimately booked the accused. That's a different aspect. Here carefully note, he did not tell anything about his cause of death or cause of injuries to his wife. Just he told that I am going to receive money from the accused. They called me to come and receive. I am going, I will get back that amount and come back within 2 days. He went in a raid. Then the statement of his wife stating that she also moved the criminal law into motion. Her evidence came for test. This is the only defense taken by, this is the only evidence. There is no other plausible evidence to connect the accuser to the case, in that case. The argument before trial court and high court have convicted the accused, no doubt, but before the Privy Council, the sole argument is her evidence is not admissible under section 32(1) because the deceased was not speaking anything with regard to his cause of death or cause of injuries also. Then how her evidence is admissible? Sans her evidence, there is nothing to connect the accuser to this case. Am I clear on this aspect? The Privy Council had to examine the purport of section 32(1). The transaction does not always need to be a real cause of death or cause of injuries. Some cause which ultimately led to his death may also be roped into the section 32(1). That is how the Privy Council held that her statement is admissible under section 32(1). For your benefit, you can read it as a very simple judgment, 3 to 4 pages. But it has thrown new vistas into the realm of section 32(1). It may not be with regard to the cause of death, it may not be with regard to the cause of causing injuries, but still it falls within the ambit of section 32(1). I request and advise all the lawyers and particularly the students of Evidence Act how to interpret section 32(1). It is a classic example. Please read it. Okay? Now come to again admission, closer part of admission. Admission section 18, 19, 21, if we take it quickly. 18 says that admissions made by the parties, admission made by their representatives, admissions made by their agents, and admission made by third parties, but having some interest in the subject matter or admissible in evidence. This is one aspect. Section 21 says that admissions made against his own interest only admissible, but not in his favor. But classic example is section 32. This is what with regard to the admissions. Let us quickly switch over to confessions. Ramanujan can, how much time I can take? I'll try. Now coming to the confessions aspect. Confessions, as we already discussed, a confession is nothing but admission of a guilt by an accused in a criminal case. Yes, I committed the offense. So, a confession is a type of admission confined to the criminal cases, admitting the guilt by the concerned accused. Since such an admission of guilt is affecting his fundamental right of liberty and life also, in almost all the criminal cases, the law wanted to provide a vast extent of protection to such type of statements. We all know that Constitution says that no man can be compelled to be a witness against himself, isn't it? Self-incrimination. Self-incrimination cannot be compelled. You, the law, nor the courts, nor the police can ever compel a person to admit his guilt. So admission of the guilt must be voluntarily and of the own volition of a person who is accused of a case. This fundamental principle, particularly the law students must keep in mind. If you read in the context of Article 20, Article 3, no person shall be compelled to be a witness against himself. That is self-incrimination. But Evidence Act says that a person can admit his guilt. These are diametrically opposite. Therefore, the law has provided certain safeguards against particularly the police, prosecution, because prosecution is interested generally to see that the charge gets convicted. That is, of course, that is their duty. Therefore, the first dog is against the police. Not only against police, against world at large. Against the world at large, some protection is given. That is in section 24 to 30. We will quickly peruse and close our interaction. First, a confession to be made admissible in the eye of law, it must be warded off from threat, inducement, or promise. Isn't it? It must be a clean admission of guilt. It must be a pure admission of the guilt. But if it is tainted by some threat by anybody, don't be misunderstanding, don't be mistaken that the threat is by police only. Section 24 never stated that it is by police. If a confession is tainted by threat, inducement, or promise by anybody, then that is inadmissible in evidence. The court will never permit the prosecution to admit that piece of admission, because it is, if the court, it appears to the court, the word appears is, word is used therein. That means there need not be a strong evidence that of that purpose that I have been induced, I have been put into threat. Suffice if he says that, accused says that this inducement, because of this threat or promise, my previous, what you call, confession may not be taken into consideration. Of course, the court can test the veracity of his statement subsequently, retracted confession we may call it. But generally, a confession should be warded off from threat, inducement, or coercion. That is what section 24. Then next comes section 25. 25 is again a particular protection against the prosecution agency, that is, police agency. No confession made before the police officer is admissible in evidence. Section 5 says that, Section 25 says that no confession made before the police officer is admissible in evidence. So it has voted off. Totally it is excluded from the purview of the law with regard to a confession made to the police officer. Then again, Section 26. We will collect 24 to 26 after some time. 24 it says that if threat, inducement or promise is offered by any person, then that confession is not valid. Section 25 is police-centric, against the police agency. If a confession made before a police officer is inadmissible and it cannot be proved, then comes 26. 26 says that we should not take it 26 as an exception to 25, rather it is an expansion to 25. 26 says that an admission of guilt rather, or confession made before some third party, but if it is made in the presence of a police officer while in the custody of the police officer, again such type of confession is also not valid. That means confession made to the police officer is not valid. Again, confession made to a third party but in the presence of the police officer, it is also not a valid confession unless it is made in the presence of a judicial magistrate. Now you understand? Section 26 says that a confession made before some third party, but in the presence of the police, while in the custody of the police, then it is not admissible. But if it is made unless it is made in the presence of a judicial magistrate, it gets some authenticity in such circumstances, then it is admissible. Now we will collect 24, 25, 26, some important decisions quickly will peruse and close our session. 24, as we discussed, threat, inducement and promise. Confession is out of purview of taken into consideration. 25, made to the police officer, it is also taken. 26, made before some third party, but in the presence of police officer, while in the custody of police officer, it is also taken away, except it is made in the presence of a judicial magistrate. In the realm of these, some important practical aspects will come for consideration. You please see a confession, if we carefully look in, we will find two types of confessions, isn't it? One is judicial confession, another is extrajudicial confession. A confession made before a judicial authority, like a magistrate, that is admissible because 24 to 26 never prevented from making a confession before a judicial officer. So judicial officer is authorized to record the confession. That you must carefully understand. 24 to 26 is not a bar. Extrajudicial confession. There is another type of confession. Confession not made before the judicial officer, but made to some third party, including the police officer. If it is made to the police officer, it is totally out of purview of the legal scrutiny. Only if it is made to some third parties, it is admissible in evidence, but the court must carefully analyze the situation, why he made, under what circumstances he made to third party. This extrajudicial confession generally is a weak piece of evidence. These things have to be taken into consideration. Okay? Then, judicial confession made before the magistrate. All of you know what is the relevant provision which imposes certain conditions to be followed by a magistrate while recording this is not by the judicial officers or lawyers. Law students can answer what are the cares should be taken by a magistrate while recording the confession. What is the relevant provision, at least any of the law students please? Yes please. Section 164 of the CRPC, very good. Section 164 of the CRPC imposes certain conditions gives certain guidelines like how to record the confessional statement. It only speaks about the statement, not the statement may be a witness statement or it may be a statement by the accused, that is confessional statement. But if it is a confessional statement, certain cases have to be taken, one of the prime one is the magistrate shall explain to the party that you are not bound to give that statement, but if you still use it, it may be used against you in the concerned trial of the case. Then, even if he is getting ready to give that statement, the magistrate shall record it. Underneath it, he shall make an endorsement as prescribed in section 164. That he has taken on the case and the statement is a voluntary one. It has been recorded by him. This endorsement should be made. So these are the precautions to be taken by the magistrate while recording it. In this realm, one thing you must note: a statement recorded in 164, confessional statement, has a presumptive value. Any of you give that presumptive value? Which section gives that presumptive value to the statement recorded by the magistrate? What is the concerned section? Section 4 of Indian Evidence Act. That is, shall presume and may presume. What is the presumption? What type of presumption attached to the statement recorded by a magistrate? Any of you, please?
114.
Section?
114.
I'm sorry, it's not. 114 presumptions are different types of presumptions. Presumptive value attached to the statement of confession recorded by a judicial magistrate. Okay. Please refer to section 80 of the Evidence Act, which gives and which attaches presumption to the statement recorded by magistrate. What type of presumption is that? The presumption generally is that he has followed the procedure and recorded it. Is the general presumption attached to it. But it is a debatable presumption, that is a different aspect. So, a presumption is attached to the correctness of the procedure followed by the magistrate is envisaged in section 80 of the Evidence Act. You can please read it. In this context, certain important decisions will come across. 2007, 12, volume 12, Supreme Court cases page 230, Aloknath Datta versus State of West Bengal. This decision clearly envisages that the duty cost on the magistrate not just following the 164 in a mechanical manner. This is a caution against the magistrates, I am specifically telling you, who record the confessional statements day in and day out. You just cannot read black letters of 164, but you have to make a prudent enquiry of the accused. What is the prudent enquiry? Suppose the police brought the accused before the magistrate requesting him to record his statement. The magistrate shall not be overzealous to record then and there itself. It must ward off the presence of the police, that they will do no doubt, but it shall not record immediately, but give a time, reasonable time to the accused to settle himself. And most importantly, it must, if necessary and if need be, in a given case, examine physically the body of and person of the accused to find whether there are any marks of injuries on the body. All these precautions logically will analyze to take care that the police have not acted against him. The police have not concocted this so-called confession. So the magistrate must be slow in before recording the 164, but must take all the precautions. It may at times not record, again ask him to come 1 or 2 days after, and it may not keep the accused in such circumstance in the police custody, but may remand him to the judicial custody or some other custody also for the benefit of the accused. Similarly, if the accused says that I don't want to give the statement, then the law says that the magistrate shall immediately take the accused from out of the custody of police and may order him in the judicial custody. These are the precautions. Supreme Court says that the magistrate shall follow in letter and spirit the purport of section 164. This is one instance. Then another important facet of this, sometimes confessional statement before the magistrate, when the matter comes for trial, the accused retracts from it. No, I have not given the statement out of my free volition. The police have compelled me, therefore only I have given. May not be police always. Some other person compelled me, therefore I have given. So this is a retracted confession. Then the question is, what is the evidence? It is recorded by magistrate. Then what is the evidentiary value of a retracted confession? This is most important. Sometimes we will come across such type of situations. We, the judges, as well as the prosecution also come up. Then what is the evidentiary value of a retracted confession made before the magistrate? That 164 statement is staggering and staring at us. But whether it has any value, or because he denies it, it is not having any value. On this aspect, very important decision of the Supreme Court way back in 1964, the Supreme Court has had, please note down, 1964 Criminal Law Journal, page 344, Haricharan Kurmi and Jogia versus State of Bihar. I will read up that particular observation of Honorable Apex Court. However, we are not unmindful of the fact that in this country, retractions are plentiful as confessions. In a case of retracted confession, the court should evidently be a little slow in accepting the confession. Although it may not be able to fully justify the reasons for his retraction. This is most important. He will retract in trial. No, I have made because I was made to do so. But he may not be able to prove substantially his retracted statement. Still the court must be slow. Court must take into consideration all the other aspects into consideration. Then only, if the court finds that other evidence is projecting him as an accused, then it may come to conclusion that this retraction is only an afterthought. Understand? Otherwise, the court cannot simply come to immediate conclusion that he has retracted but he has made before a magistrate. Why should not I accept it on its face value? That should not be the attitude of a trial judge. This is what the principle laid down by the Supreme Court. This has been followed often by in subsequent judgments. You can write in one important judgment, Paramananda Pegu versus State of Assam. This is also very important judgment so far as confessions, the validity of confessions and retractions, etc. 2004, Volume 7, Supreme Court cases, case 779. So, a retracted confession cannot be easily brushed aside. Down that it is only an case. The court take first of all key confession, call for the prosecution, always on the prosecution, whether it could able to prove the case otherwise. The court may come to conclusion that this is retraction is only an afterthought by the accused. It need not and it can also be taken. It has to be dealt with by the court. Then facet of the they present a confession recorded by under section 80. Whether that presumptive value can be not recorded by the magistrate. Right? That is attached to the confession statement can be attached to a die declaration recorded by the similar magistrate or the same magistrate. Any of you answer? Understood? There is correct. That is attached to a confession statement. Whether the same presumption can be attached under section 80 to a die declaration recorded. Yes, sir. It is not. The Supreme Court has no such presumption can be attached so far as die declaration is concerned. It must be established that all the cases have been taken by the magistrate who records it. That is why a magistrate, if magistrate happens to record the magistrate, even if the magistrate records it a die declaration, still it has to be examined. He must pronounce that he has taken all the cases and recorded it. Another reason for not presumptive value to die declaration is a die declaration is not given on oath. The court held that die declaration is not made on any oath. So, attaching any value will be against the interest of the accused in the future trial. These say that section 80 is not attached to a die declaration. Bombay High Court, a full court judgment by Honorable Justice Bonesley. His Lordship happened to be the acting Chief Justice for our combined High Court of the AP. And his Lordship by then was the Bombay High Court Senior Judge. And a full bench led by his Lordship has pronounced this judgment, a very, very elaborate judgment. I recommend to read all the decisions up to date, up to 2008, with regard to the die declarations have been discussed at length. Please note down. Ramesh versus State of Maharashtra, 2011, Volume 6, Maharashtra Law Journal, page 927. This is full bench of the Bombay High Court, which was subsequently approved by the Supreme Court. So, this judgment I recommend for all the students as well as the lawyers to read, to know how the various facets of die declaration have been dealt with. Of course, after 2008, some more judgments have come, but they fall in the line of this judgment. Okay? Another aspect also dealt with in the very same judgment. While giving evidence, the magistrate who recorded the die declaration, whether he need to give the first person account of that deceased, that means give the details as spoken before him by that person who gave the statement, or sufficient if he gives a gist of what has been recorded by him. This is also dealt with by the full bench and held that no, he need not necessarily give the entire account of what has spoken by the injured person. Sufficient, the important gist of what has been spoken and what has been written by him. If he stated, it will be sufficient. These two aspects you will find in the what you call this full bench judgment. Then another important aspect attached again, because we are the confessions. Sometimes we will find out. 15 minutes. 15 minutes, okay. Another important aspect will come in the arena of confessions is confessional FIRs. Sometimes a crime will be committed by a person. He himself goes to the police station and gives a statement that he committed. Sometimes you will find he will go with the weapon with which he had committed and makes a statement before the police that he himself has committed, basing on which the police will record his statement and registers the FIR. But when the trial comes, he retracts. No, I have not given. The police have made me. They cooked up the FIR as if I have given the statement that I have committed the offence. I never committed offence, nor I have given the statement. It is, he retracts from the confessional FIR. Then what is the evidentiary value of this retracted FIR? This also came for judicial scrutiny. Understood what, particularly the students? Are you able to understand? Sometimes it so happens, but maybe rare. The accuser himself go to the police station and says that I have committed. In a case, if you will be wondering, he chopped off the head of a person and took that head and placed on the table of the police station house officer. This is how I committed the offence. It is a shuddering experience to the station house officer, but it was a truth in a given case. So if such, basing on the confessional statement of the accuser himself, if an FIR is registered and investigation completed and charge sheet is filed against the very same accused, but during the trial, he retracts that I have not given that FIR. What is the evidentiary value of that FIR is the question. Therein, it has been held in a very famous case which has discussed all these nuances of confessional and retracted FIRs. 1997, AR 1997, Supreme Court, page 496. This is arising from the AP High Court, Bandlamudi Achyutaramaya versus State of Andhra Pradesh, which dealt with this confessional type of FIR. Later it retracted. How to deal with it? In that context, it was held that a confessional FIR, generally it is like a previous statement of person. Generally, FIR is, general purpose of an FIR is, it is not by accused, but generally, victim's FIR, what is its purpose is, it is for the purpose of contradiction by the other party and also for corroboration, unlike 161. But that principle to be applied to the accused's FIR is not possible. This Supreme Court held. You can't contradict him because he will not come to the witness dock. You can't also corroborate because it is a self-incriminating statement given before the police officer. It is hit by section 25. Understand? So it can neither be contradicted nor corroborated. Therefore, what is its evidentiary value? This is what the Supreme Court has discussed. It can be neither contradicted because he will not come to the dock so that you can put him on his face. Nor you can corroborate because it was made before, even admission of the prosecution is that it was made before a police officer. It is hit by section 25. So in this type of frequent situations, what is its evidentiary value? The Supreme Court held that its evidentiary value is confined only to the extent of section 27. Understand? What is section 27? A discovery of a fact to the effect that some incident has occurred, incident of death of murder has occurred of a particular person. Only to that extent it will serve the purpose. But the other part of self-incriminating purpose, self-incriminating part cannot be proved. Understand? So the validity and the usability of FIR, self-incriminating FIR is only to the extent of recording that a particular murder has taken place or particular crime has taken place. But who has done it, though it contained in the FIR, that part cannot be relied upon by the prosecution. That is what held by the Supreme Court in the year 1997. I request you to read the very interesting judgment. The last one, of course, is extrajudicial confession. I have already stated that extrajudicial confession means confession made not before the judicial officer, but before some third party. A third party before whom the accused goes and makes a confession that I have committed offense, please save me somehow. He may be made before his own kith and kin, or before his friends, or before some elder of the village, whatever it be. It is called as extrajudicial confession. Again, what is its evidentiary value is the question. The law is not the more recent era. It has been decided. Primarily, a confession of extrajudicial confession is a weak link, means weak piece of evidence. But it can be relied upon by the court after taking into all the circumstances, particularly that there is every possibility that this accused might have made a confession before that particular person. There must be very strong circumstance as well as evidence for that purpose. Then only the court may accept it. Otherwise, generally, a confession made before a third party is a weak link. Why? Because nobody will accept his guilt. That is the common tendency of a human being. Basing on this common principle, it was held by the Supreme Court in a number of cases that it is only a weak piece of evidence. Right from very famous judgment, Agnew versus State, the oldest one, the year 1966 Supreme Court, page 190, that has been repeated even now also. Thereafter, another important judgment is year 92, page 922.
In those lines only, even now also the recent judgments have been pronounced that it is a weak piece of evidence, though there is no taboo for the court to accept it, accepting the confessions. So friends, this is with regard to the admissions and confessions. 27, of course, you know that it is only that part of the discovery. Discovery means not only a weapon or a physical item. Discovery of fact with reference to particular place or location which is within the knowledge of the accused. 27 must be understood in that sense. A very famous judgment I will quote and close my discussion. That is Pulukuri Kotaya versus or is a Privy Council judgment, AR 1947, PC, page 67. In this it was held, again it was from the AP, this decision, Pulukuri Kotaya versus or section 27. Recovery of fact should not be mistaken as only a recovery of some weapon or some blood-stained clothes, etc. It also follows with it the particular location where from it was recovered. Because the discovery of a weapon you need not discover. Such type of weapons have been there even prior to that one. Such type of clothes are always been there. You are not discovering anything new. But what you are discovering is its location as spoken by the accused. This is the connecting clause. Therefore, discovery will have a validity only when physical item discovered on the revelation made by the person which is to his exclusive knowledge. This must be proved by the prosecution. Understand? So discovery should not be mistaken. This is what Privy Council held. Not always a weapon or bloodstained clothes or some physical object, but the location where from it is discovered, that location is to the exclusive knowledge of that particular accused. If this fact is proved, then the discovery is admissible in evidence. So this is Audience, with regard to the admissions and confessions, only 3 or 5 minutes. Any doubts or any questions or any new decisions if you have found, I will invite from you. Any of you? Yes, one aspect, because of the time constraint, I have not discussed. If the Ramaragaru permits me, only one aspect I will take. Confessions of a co-accused. Sometimes we will come across under section 30. Confession of a co-accused. There are a number of accused jointly tried for the same offense. In that trial, one of the accused makes a confession of guilt. Then, whether it is admissible or not, for which there are some set pattern is set out in section 30. First of all, it must be an inculpative, not exculpative. What does it mean? Inculpative statement means he must include himself, he must incriminate himself and other accused. This is the first condition. They must all be tried together and joint trial for the same offense. This is another condition. If these conditions are satisfied, the court may take into consideration the confession of a co-accused as against other accused also. But what is the problem in accepting it? As is put it by the land advocate, two other sections in the same evidence act will come against it. The first one is section 114, presumption. An accomplice is presumed to be untrustworthy. An accomplice is presumed to be untrustworthy. Then how we are relying upon the confession of co-accused? This is diametrically opposite, isn't it? Oxymorons, we call in English. Oxymorons means two cannot fit into. One must be true, then another must not be true. If 114B is true, that means a co-accused is unworthy of credit. Confession of a co-accused is unworthy of credit. How section 30 says that you can accept it is again one puzzlesome question. Not only there, again you have to refer to section 133 of Evidence Act. 133 evidence says that no conviction recorded on the basis of the confession of a co-accused is invalid. Again. So 30 and 133 are one way and 114B is to some extent against this principle. Then the Supreme Court has made an interpretation of law. This is what the interpretation of the statutes. Section 30, section 114B and 133 together interpreted by the Supreme Court in such a manner that there must be an harmonious construction, that the provisions, the same provisions in one enactment or different provisions in different enactments are diametrically opposite. We cannot attribute to the lawmakers that they are redundant. One provision is redundant or other provision is redundant. On the other hand, courts must take all the provision into existence but make a harmonious construction. This harmonious construction principle was followed in this respect. Section 30, 114B and 133, and Supreme Court held that yes, you can record conviction basing on the confession of a co-accused. But since 114B says that such a confession by a co-accused is untrustworthy of credit, you have to go into the facts of the case, and though not law requires, but prudence requires calling for a corroboration on material particulars. Understand? Simpler terms, confession of co-accused should be kept aside. The court must call for the prosecution and ask it whether you could able to prove your case behalf of this confession. If it able to establish its case to a larger extent, then the court may take into consideration the confession of co-accused to rope in the other accused, to convict the other accused also. This Supreme Court held that it is by way of prudence but not by the requirement of law. Law never stated, but the harmonious construction made by the Supreme Court in this fashion. The court, trial court or appellate court, whatever it be, must first of all aside the confession of co-accused and direct the prosecution to establish its case independently, and if it could able to establish to a larger extent, the court may then as a supplement take into consideration the confession of co-accused. Rightly has reminded me, I will give the judgment. AR 1985 Supreme Court, page 866. AR 1985 Supreme Court, 85 Supreme Court, page 866. Shirshil Nageshi versus State of Maharashtra. Of course, there are other judgments also. I could readily get this judgment. So this is the principle behind it. How to accept or not to accept the confession of a co-accused has been dealt with the Supreme Court. Yes, any other questions or we can? Yes, please. But with the permission of Nagi. I must be careful. Yeah. In what context?
Miranda Act, the USA says the police should tell the accused that he has a right to remain silent and they will collect the evidence.
Silent has been enunciated right from Constitution to Criminal Procedure Code to every law. It is understood. It is understood.
Accused speak of, his silence is accepted. But sometimes his silence will be taken. It is under the Constitution itself. That's all.
Even Indian Evidence Act, segments are not conclusive. Whereas Section 58 of Indian Evidence Act, facts submitted need not be proved. Here, at the best, they may be taken as established under Section 7 of Indian Evidence Act.
Section 31 an admission is not a conclusive fact situation of that case. If an admission is found to be civil case, you are asking in the context, probably, isn't it? In context, your admission is made a aspect. Then admitted fact need not be proved under Section 58. In my view, this proposition and Section 58 laid down proposition are not diametrically opposite. They are speaking of one thing only. Suppose the admission is directly in respect of fact and issue. That is why I have discussed what is fact and issue for the benefit of one and all. If the admission is directly with regard to the fact and issue, then that part is not necessarily to be proved in the trial by the other party, only to that extent that Section 58 says that. I will be more elaborative. In a pro note suit, I am again come to a very nominal, very simple example. Defendant may take different cases. Executed pro note. I have taken money, example if I remember. I want only installment decree. Where is the question of trial court asking the plaintiff to prove your case, because he need not prove anything there. There is an admission is in respect of fact and issue entirety. Okay? Then sometimes there 58 comes into play. The other aspect, in a pro note, the defendant says that I have executed what you call here, because of the fiduciary capacity. If you go to the Contract Act, fiduciary means one person will be in a position to control the movement or the mind of the other, doctor, like that, lawyer, client, principal agent, like that. So using that, he has got this one, what you call, obtained this promote, but I have not executed. In such circumstances, though this admission of even executing the promote is there, still the court in its wisdom may frame an issue that whether the promote was executed voluntarily or not, and may also direct the plaintiff, because the burden of proof will never shift. Burden of proof will lie on him. Only onus shift from one person to another. In such a case, the court may still direct the plaintiff to prove his case. So 58 in this proposition that admissions are not conclusive proofs, in my view, they are not diametrically opposite. They are one and the same. We have to use in the context of a case. That's all. I am exceeding my time. Yes, thank you all. Thank you, sir.
Hungry but not angry. Only a few minutes we will finish this lunch session. I request Narsingarao Garu, Rola Madai Garu, along with Mata Jaikar and Jailashmi Garu, representing the association, to felicitate the.
Thank you, sir.
Thank you very much, sir. The pre-lunch session very interesting. First session CPC, typically criminal cases. Now evidence. All of you keep some space for the third session. Please come and pay your attention the next session also. Thank you.
attention, but maybe His Lordship just take it in. You outside, please kindly ask them to come inside, because work in official court thereafter and elevated to High Court. Not only that, he is one of the few judges who is having technology to His Lordship's credit. He has almost command over the technology, seized the technology, and without loss of time, I request Justice Chakravarti Garu to proceed with his presentation.
Good afternoon all, sir. Good afternoon, sir. Am I audible? Disturbance. After a sumptuous lunch, generally everybody will be feeling a little bit tired. I don't want to bother you more, but you know, after advent of the technology, the whole scenario has been changed, particularly in respect of the course. The total approach has been changed. Now, there is no difference between traditional offences or cyber crimes. For that matter, in civil cases also. Every case, in one way or other, now we have to face electronic evidence. We can't avoid it. Unless you know the nuances of the technology, you can't compete in the survival of the fittest. Now, and competent only survive. Today, I got over 15 years in this field. I started my career as a magistrate of the first class. Etc. But after some time, why I am saying all this is, many people feel that technology is a rocket science. But I feel in 2004, the High Court of Andhra Pradesh has provided computers to every court. My court also received one computer, but we do not know what to do with it. A man from Vendar visited the court, just installed it, went away. Day in and out, I am coming to court and seeing that just like ornament. But after some time, train our staff members. Then I requested my staff to attend his class. After 3 or 4 days, I asked the trainer, "Sir, what is the progress?" He said, "Sir, who is coming?" "No one is coming." I said, "Why?" "Sir, everybody is leaving the court after 5 p.m. Then I thought it fit to stay myself in the court and sit in the class so that staff will also sit along with me. After 2 or 3 days, then I developed some passion and inclination to nuance the technology. Then thereafter, I never left the technology, and it took me to heights, because knowledge is the power, you know all. Specialization take you to heights. Posted as president, the famous case, an account of my knowledge in computers by the Court of Andhra Pradesh, and then I was continued as president. I was in one court for. I can say that because of my knowledge in this technology, who are highly complicated, involving technology, I was this is the power of technology. And then I was brought to High Court as my reasons for my elevation. Technological days, you can't avoid. If you doesn't know the nuances of the technology, you will stop here. You can't go forward. So, the learned advocate and budding students in law who are tomorrow's advocates or maybe judges of the future to technology, relating to technology. But what I always advocate is that you must know basics of the technology relevant to our. You may not be in a position to appreciate what is placed in front of you or before you is a genuine one or a fake one, or whether it is having credibility to rely on. You see, just video. You will find celebrities. Virat Kohli, Shah Rukh Khan, etc., etc. And you might have heard videos. Some to test about that piece of evidence that is known as electronic evidence. Basically, to share information or thoughts on the forensic basics of the electronic evidence. Of course, one is regarding of an electronic record and another is provided. First of all, electronic record. What is the relevant provision in law which recognizes electronic documents? After amendment would speak that all documents including electronic records produced for the inspection of the court is evidence. Evidence means and includes all statements. Second part is all documents including electronic records produced for the inspection of the court. Am I right? So, Section 3 of the Indian Evidence Act is recognizing electronic records as evidence. Am I right? Then, what is the corresponding provision in IT Act which is recognizing electronic records? Chapter 3, Electronic Governance. Section 4, Legal Recognition of Electronic Records. Where any law provides that information or any other matter shall be in writing or in the typewritten or printed form, then notwithstanding anything contained in such law, such requirement shall be deemed to have been satisfied if such information or matter is rendered or made available in electronic form and accessible so as to usable for a subsequent reference. So, Section 4 of the Information Technology Act 2000 is legally recognizing electronic records. These two provisions under the Indian Evidence Act 1872 and Information Records. Indian Evidence Act recognizes it as evidence. Then, what is meant by, whether the Evidence Act defines electronic record, what is electronic record? Then next question is, what is an electronic record, where it was defined? Whether the Indian Evidence Act 1872 defines electronic record anywhere or another statute is recognizing it. Then read the relevant provision for our benefit. Section 2, subclass T, T for Tamil Nadu. Electronic record means data, record or data generated, image or sound stored, received or sent in an electronic form, or microfilm or computer generated microfiche. This is the definition of electronic record. Then again, electronic record contains certain definitions. One among them is data. Data, what is meant by data? It is also defined by ID Act, Section 2, subclause O for all. Data means representation of information, knowledge, facts, concepts or instructions which are being prepared or have been prepared in a formalized manner and is intended to be processed, is being processed or has been processed in a computer system or computer network, and may be in any form including computer printouts, magnet stored internally in the memory of the computer. Why I am reading these basic provisions? If you know these basic provisions only, you can better understand Section 65A and Section 65B of the Indian Evidence Act, which speaks about admissibility of electronic records. Without knowing these definitions, you can't read and understand Section 65A and B of the Indian Evidence Act. Then, is there any judgment of our High Court defining what is computer? Do you ever come across it? Do you ever come across the judgment of our AP High Court defining what is a computer? Our High Court, Common High Court, Syed Asifuddin case, Syed Asifuddin versus State of AP, 2005 Criminal Law Journal 4314, has dealt with the definition of computer, mobile phone, etc., computer network, computer system, what laid down in IT Act. I request all of you to go through that judgment meticulously so that you can have a basic understanding of legal perception of computer, computer network, computer system, mobile phone. Due to paucity of time, I am not going into details now. Sir, 4314. Criminal Law Journal 4314, sir. 2005 Criminal Law Journal. Syed Asifuddin versus State of AP. And what are the electronic records? Various electronic records we handle in day-to-day life, particularly in courts, which come under the definition of electronic records. There are many, like call data records. The most commonly produced electronic record in criminal cases nowadays is call data records. Am I right? And then emails. Am I right? Then CCTV footages. Now police are relying on CCTV footage also. Computer files, both in criminal as well as civil cases, because everything is being computerized now, including bank records. You know that nowadays bank records, that is banker books, we generally call in legal language, banker books, are all computerized now. No more physical books. So, do you ever read that banker books Evidence Act with reference to admissibility of banker books in electronic form and what is required to be produced by the bank to prove the banker books produced in a court of law. You may be under the impression that Section 65B will apply. I am sorry to say Section 65B has nothing to do with Banker Books Evidence Act. Banker Books Evidence Act is having its own provision, Section 2 of the Banker Books, which is almost similar or parameteria with the provision under Section 65A and 65B of the Indian Evidence Act. Hitherto, bankers were producing a certificate along with the banker books certifying as per the certificate provided under the Banker Books Evidence Act. Now, when they produce these banker books in electronic form, they are expected to produce a certificate as per the amended Banker Books Evidence Act. In enact cases, you will be coming across bank statements. Have you ever seen they were certified as per Banker Books Evidence Act? This is happening. We are allowing. We are relying. This is where we are lagging behind because we are not updating ourselves with the latest amendments of law, more particularly with reference to electronic records. And then this is the basic legal principles. Then coming to admissibility of a document. Generally, we follow 65, 66 of the Indian Evidence Act with respect to documents because Section 3 says documents includes electronic records. You are all aware the judgment of the Apex Court in Parliament attack case, Afzal Guru's case, Professor, who was hanged later. In that case, call data records were produced by the prosecution to establish conspiracy. Afzal Guru was prosecuted for the offence of conspiracy regarding attack on the Parliament. He was not directly participated in the offence. He was prosecuted for conspiracy. So, the prosecution to establish conspiracy relied on certain call data records, conversations. Then, at that time, Apex Court held that 65B is not mandatory as such. Even if no certificate is there, we can rely on secondary evidence. If Section 65 and 66 of the Indian Evidence Act conditions are complied with. But later, you know the famous celebrated judgment. What is the judgment? Changed the field. Subsequently, one celebrated judgment of the Honorable Apex Court changed the position regarding admissibility. That is, Anwar PV versus PK Bashir and others. Anwar PV versus PK Bashir and others. 2014, 10 Supreme Court cases 473. Every council must read this judgment at least one time to know electronic records. Why electronic records require a certification under Section 65B? Yes, statutes say that a certificate is required, but why? Because of this. Falsity, tampering, modification, alteration, interpolations are very easy. Electronic records are vulnerable to tampering. So, to get an authentication, Parliament in its wisdom introduced special law relating to electronic records regarding admissibility of the evidence, 65A and 65B. So, in Anwar's case, what Supreme Court said is that without certificate under section 65B, 65B lays certain guidelines. What should be there, should be the content of the certificate. I am not going into the details now, because if I go also details, you shall sit here for 2 or 3 days. Supreme Court said that certificate is mandatory. In those cases, do you know the facts of that case? It is a civil case, in fact. It is an election dispute where one party produced compact disc CDs. Do you admit that CD is an electronic record? What is the electronic record? CD or content in the CD? Only CD is only the folder of the content. Supreme Court in Thomas Bruno case and other cases also said that CD is containing some data or information is an electronic record. In that case, CDs were produced before the court that opposite candidate has made certain statements during elections attracting People's Representation Act. Then Supreme Court said that those CDs are inadmissible since they were not certified under section 65B of the Indian Evidence Act. That was the cause for Supreme Court to consider section 65B of the Indian Evidence Act. Then later, you know the development of law. Shafi Ahmad case, some diversion from Anwar's case. Shafi Ahmad case held that the person who is not in possession of that computer system or gadget cannot be required to produce 65B certificate, because he may not be in a position to give that certificate because he is not in possession of the gadget. On account of that divergent views, again Supreme Court was called upon to pronounce an authoritative judgment regarding section 65B of the Indian Evidence Act. What is the judgment, sir? Arjun Pandit Rao's case, that was rendered in July 2020. Every advocate or a student of law must read that judgment. It's not only 65B. Whole gamut of the electronic records was considered and discussed in the judgment. Not only its admissibility. Admissibility is only a small part. You know, it is only a mode of proof. Certificate is only compliance regarding mode of proof, that's all. It doesn't go beyond that. Means merely because an electronic record was supported by section 65B certificate, does it mean to say that contents are to be accepted as gospel truth? No. Contents has to be proved as like any other document. So, contents if proved, then we have to decide its probative value, whether it is a reliable piece of evidence, whether it is credible, and it inspires the confidence in the mind of the court as a truthful piece of evidence. These are the issues, latter issues. So, to decide these issues after admission, one must equip himself with the basic knowledge relating to certain electronic records, more particularly regarding CDRs, emails, CCTVs, social media records, etc., mobile phones, etc. Unless you have that basic knowledge, you may not be in a position to know its probative value, to find out whether it can be relied on or it can be considered. For example, next question is whether certificate can be produced at a later stage if not produced with the document. Anyone? How? For example, certificate is not produced with the document, sir. Then prosecutor intends to file it at a later stage. Trial is not concluded. It was decided in Arjun Panditrau's case itself. The lordship held that application can be made to court when requisite person refuses to issue certificate. Such certificate means, suppose you will produce a document, you don't have any certificate, gadget is in my custody, I refuse to give certificate to you. Then what the Supreme Court said that you can file an application before the court to direct that person to give a certificate. And the court may, in appropriate cases, allow the prosecution to produce such certificate at a later point in time. Means if trial is not concluded, court may allow the prosecution to produce such certificate at a later point in time. Now, this is also extended to defense. This concession was allowed to defense also. What is the case? Very recent judgment. Sir? That is, recent judgment is State of Karnataka versus T. Nasir, criminal appeal number 6548 of 2022, wherein the apex court referred Adv. Panditrau's case regarding this aspect and said that this concession is also available to the accused. Sir, what is the difference between admissibility and mode of proof? Of a piece of evidence. There is a lot of difference between admissibility and mode of proof. This was explained in clear terms. Every advocate shall read this judgment. RVE Venkatachala Goundar versus Arulmigu Venkateswar Swami and VP Temple, 2003 AR Supreme Court 4548. Very famous judgment. One must read. Advocate conducting trial before the district judiciary must know this judgment. Page number is 4548, sir. Famously known as RVE Venkatachala Goundar's case. And you know later judgments, Bipin Santilal Panchal's case, AR 2001 Supreme Court 1158. AR Supreme Court 2001 1158. Then of course Sandhu's case, Afzan Guru's case, 2003 6 SCC 641. And then Shalimar Chemicals case, 2010 8 SEC 423. These 5 cases one must know while conducting the trial, either in civil cases or criminal cases. When you want to say any objection regarding the admissibility or mode of proof, without knowing these judgments, you cannot conduct a trial in a civil case or criminal case. I said compact case, disc CD. CD case is KK Veluswamy versus Palaniswamy, 2011, 11 SEC 275, 2011, 11 SEC 2075. And another judgment is Samsher Singh Verma versus State of Haryana, 2015 lawsuit, Supreme Court 115. These are some of the judgments, sir, regarding admissibility. And then coming to CDR, sir. What is meant by CDR? In the common language, CDR, call data records. I'll give some hypothetical examples. Suppose a complaint was made alleging that here you gave or you sent a message containing some abusive language or hated speech to high profile or constitutional authority. Then police registered a case basing on your mobile number. They come to you. You say that I didn't send. Police produce CDR before the court. It contains your mobile number. They will produce application furnished by you or provided by you to the service provider at the time of taking the service. It will connect you with that number. CDR shows your number, CDR shows the other number, time shows, date shows. Your plea is that I didn't send the message, but document in front of you stating against you. What will you do? You may say that police fabricated the CDR. That is a general reference. Everything is false nowadays. See, this is how conversation goes. You make a call or send a message, immediately it will go to the convenient nearest tower, cell tower, then it goes to the base station of the service provider, and from there to the receiver wherever to the nearest cell tower, and from there to the receiver, sender, receiver, just a small cycle. It happens in seconds. Am I right? Just to make a call or send a message immediately within no time. It will go through all these process. So it's an automated process, no human intervention. Then CDR, it will generate CDR. This process will be recorded in the form of a CDR known as digital stamping. This is what is called as digital stamping. CDR is nothing but digital stamping of a call or a message sent from one mobile phone to another mobile phone. Like when you, in good olden days, when you are sending a letter, posting at Vijayawada, reaching Delhi through several post offices, having stamps. Similarly, it will have its own digital stamping. This digital stamping is known as CDR, call data record. This is generally, this is what general CDR, calling party, called party, date, time, duration, first cell ID, last cell ID, cell type, IMEI, IMSI. Generally columns you will find, but I will put a one question here. What is the body in India which regulates that CDR shall be like this, it contains this information, etc. What are the rules governing this? Have you ever thought of it? Police are filing, we are going with it. Or parties are filing, we do not know whether it contains all the information as per the regulations. Am I right? Have you worked in that way? Who is the controlling body? Who will prescribe? ఇప్పుడు చెప్తున్నారు మీరు, నేను చెప్పిన తర్వాత TRAI will prescribe certain regulations and guidelines. What should be the columns, what should be the information and how it should be maintained and how long it should be maintained and how copy should be given. IT Act, do you ever come across the word intermediary? Intermediary. Section 7 of the IT Act deals with intermediaries, and section 67C of IT Act says that central government shall notify guidelines regarding maintenance of the electronic records by the intermediaries and period of maintenance. Recently, Government of India issued guidelines, 2021 guidelines. They shall maintain minimum for 1 year as per that guidelines. And what is the relevant section in Indian Evidence Act relating to these conversations? Have you ever thought of it? 5 to 55. In the earlier session, we discussed regarding the relevancy of the evidence, how they are relevant, what is the relevant section under Indian Evidence Act. Sir, we must be in a position to assist the court. Generally, 3 C's we will come across in courts. One is who is convincing the judge. C for convincing the judge, having knowledge and who knows very well about the facts and law. He will convince the judge. Another is who will confuse the judge. And finally, third C, who always confront with the judge. First one is only will live for longer. The other two may perish shortly. It is a universal truth. First C will only live forever. Other two C's will perish one time or other shortly. So, we must section 39 Section 39 of the Indian Evidence Act deals with Pandit Arjun Rao case deals with section 39. There is a direction to the intermediaries in Pandit Arjun Rao's case to preserve these call data records until government makes certain guidelines and regulations in this regard under section 67C of the IT Act. Section 39 of the Indian Evidence Act. Have you ever thought of it? How CDR is relevant? Section 39, 5 to 55. It falls under section 39. That is how it is relevant to the fact in issue. When fact in issue is whether you sent a message, hatred message to XYZ. This is the fact in issue. CDR is relevant to that fact in issue under section 39 of the Indian Evidence Act. This should be the approach. Just they are filing. And then go to, you see, cell, there are certain columns, cell ID, last cell ID, first cell ID, cell ID. Generally, we will see only calling party, called party, day to time, duration. Ante kadandi, ive chustam. Calling party lo మీ పేరు ఉంది. కాల్ పార్టీలో అవతల పార్టీ పేరు ఉంది, నెంబర్ ఉంది. ఐ మీన్ డేట్, ఇవాళ డేట్ ఉంది, టైం, ఇప్పుడు టైం ఉంది, డ్యూరేషన్, ఎస్ఎంఎస్ అయితే డ్యూరేషన్ ఉంది, అంతే చూస్తారు. కాబట్టి మీరు ఇప్పుడు ఇక్కడ నుంచి XYZకి ఎయిట్ మెసేజ్ పంపించారు. దేర్ ఎన్స్ మ్యాటర్, దిస్ ప్రూవ్స్ 65B సర్టిఫైడ్ ఈజ్ దేర్. ఎయిర్టెల్ వాడు వడపడ వస్తాడు, సిడిఆర్ ప్రింట్అవుట్ తీసామండి, 65B సర్టిఫైడ్ ఇచ్చాము, అడ్మిటెడ్. దిస్ ప్రూవ్స్ మీ ఫోన్ నెంబర్ ఉంది, అవతల వాళ్ళ ఫోన్ నెంబర్ ఉంది, టైం డేట్ మ్యాచ్ అని అప్లికేషన్ సర్వీస్ ప్రొవైడర్ ఇస్తాడు, అది మీ పేరునే ఉంది, ఆ సర్వీస్ ఫోన్ మీరే, యువర్ బుక్డ్ కదా, అయిపోయింది. బట్ దేర్ ది రోల్ ఆఫ్ అడ్వకేట్. ఫస్ట్ సెల్ ఐడి, సెల్ ఐడీస్, యూ మస్ట్ నో వాట్ ఈస్ దిస్ కాలమ్స్. ఈ కాలమ్స్ ఏమిటి, వాట్ దే information they will give. Every advocate or judge dot guidelines, ఈ ఇన్ఫర్మేషన్ అంతా ఉండాలండి. కాలింగ్ పార్టీ, కాల్ డేట్, కాల్ టైము, ఫస్ట్ సెల్ ఐడి, లాస్ట్ సెల్ ఐడి, కాల్ టైపు, IMEI నెంబర్స్, IMSI నెంబర్స్, టైప్ ఆఫ్ కనెక్షన్, ప్రీపెయిడ్, పోస్ట్ పెయిడ్, SMS సెంటర్ నెంబర్, first roaming, etc. These details. CDR analysis. Generally, CDRs are four types. Four types of CDRs. They are CDR of accused, means one party, suspect or victim. Site means tower CDR. Okay. The last picture I have shown the towers. Immediately after making call is going to towers. That is known as tower CD. It contains lot of numbers. For example, మీకు ఇక్కడ దీని ఇంపార్టెన్స్ ఎక్కడంటే, నేను ఒక హైపోథెటికల్ అంటే ఒక మూవీలో, సినిమా పేరు మర్చిపోయాను కానీ, one high profile man was murdered at some place, dehearts of public. Police reached the scene of offence. No eyewitness. They are trying to investigate to find out call data of certain suspects. But they could not get proper details. Then they collected the tower dump of the nearest towers, CDRs. A relevant time low, what are the calls passed through that towers? They started filtering. They got some suspect numbers passing through that area. But they could not connect the other man. It is a criminal conspiracy, serious criminal conspiracy involved high profile and sensitive persons. CDR was provided by the service providers, but it doesn't have any details connecting the high profile suspected persons. Then finally, the officer, police officer, did not agree with the CDR provided by the service provider. He doubted some tampering was made to the CDR copy provided by the service provider. Immediately, he contacted his friend who is an hacker. With the help of his friend, though it is illegal, he hacked the service provider server and could able to get the original available in the server of the service provider. It contains some numbers which were not found in the CDR submitted to the court. Those numbers connecting certain people. This how evidence will be tampered. That is why even if 65B certified is there, you can't take it as a truth itself. Then what is the remedy available? Section 45A. Did you ever come across Section 45A? What is Section 45A of the Indian Evidence Act, sir? A of the Indian Evidence Act. It was included in the year 2009 when in a proceeding the court has to form an opinion on any matter relating to information transmitted or stored in any computer resource or any other electronic or digital form. The opinion of examiner of electronic evidence. Examiner of electronic evidence referred to in Section 79A of the Information Technology Act 2000 is relevant fact. So it says that the opinion of examiner of electronic evidence referred under Section 79A of the IT Act. Then we have to read Section 79A of the IT Act. This is how we have to understand the law. Chapter 12A of the IT Act refers examiner of electronic evidence. 79A, central government to central government. So why I am stressing on it? Only central government. State government has no role. Central government to notify examiner of electronic evidence. The central government may, for the purpose of providing expert opinion on electronic form evidence before any court, this is important, before any court or other authority specified by notification, this is more important, notification in official gazette, any department, body or agency of the central government or state government. Means the body must belong to either to the central government or state government. So no private bodies are included under Section 79A as an examiner of electronic evidence. The word electronic evidence was used only here. Earlier, the word wherever you see electronic records, first time only electronic evidence, the word electronic evidence is being used under Section 79A. What is electronic evidence is specified in this section. Electronic form evidence means any information of probative value. Why I am stressing on probative value? That is either stored or transmitted in electronic form and includes computer evidence, digital audio, digital video, cell phones, digital fax machines. These will fall under the definition of electronic evidence. If any probative value is under dispute regarding the content of these electronic form of evidence, and court has to form an opinion, then under section 45A, court can ask the examiner of electronic records appointed under 79A to examine and give a report. Do you know API Court judgment on section 79A? Have you ever come across that API Court has rendered a judgment on 79A? In 2017, 1 ALT criminal, page 100. 2017, 1 ALT criminal 100. A perusal of the section clearly demonstrates that the central government has to issue notification identifying any department, body or agents of central government or state government as an examiner of electronic evidence. The Parliament in its wisdom incorporated section 79A of Information Technology Act in order to prevent malicious prosecution basing on the expert opinion given by unrecognized bodies, laboratories. Section 45A of the Indian Evidence Act enables the court to send the electronic document to the expert for opinion in order to place reliance on it. To place any reliance on the opinion of an expert, the electronic document should have been sent to the recognized laboratory through the court. This is the ratio. This was rendered in the case of Nara Chandrababu Naidu versus State of Telangana in 2017. Then, coming to our CDR, reading of CDR, sir, you must know, every advocate must know how to read a CDR. If you conduct any examination, either chief or cross, without knowing how to read a CDR, you are doing injustice to your client. I have no hesitation to say. Calling party, normally, you know, who is making the call? Called party, who is receiving the call? Day to time, of course. First cell ID, last cell ID. These are the two most important aspects. What they indicate, they contain certain numbers. Are you able to see that numbers? First number is 404. In first cell ID, it contains digits divided into 4 parts. First part is MCC. What it would indicate? What is meant by MCC? MCC means mobile country code. Mobile country code. For India, 404 for example. Mobile country code of India as per the international standards is 404. Then what is 20? It is known as MNC. What is meant by MNC? Mobile network code. Mobile network means who is the service provider. Suppose if it is AP, it would be different, some other number. That is where I gave an example. Suppose this mobile network code shows that Airtel Hyderabad, not as Vijayawada. Then what would it indicate? That call was from Hyderabad. So, if your defense is that somebody hacked your phone and sent a message, it will lend a support to your defense. First four may tally, but here, where suppose 404 is not there, some Kazakhstan number is there. You know, I must tell you here, spoofing technology. Have you ever heard spoofing technology? Ina cinema chusara, Kamalasan cinema. Have you seen that movie? I am not making any recommendations. Just disclaimer. My disclaimer is I am not making any. Danlo is making calls from different places. అంటే ఈ క్షణంలో ఇండియాలో ముంబై నుంచి చేస్తే నెక్స్ట్ మినిట్లో ఆస్ట్రేలియా నుంచి వస్తుంది కాల్, ఆ నెక్స్ట్ మినిట్లో లండన్ నుంచి కాల్ వస్తుంది, ఆ నెక్స్ట్ మినిట్లో న్యూయార్క్ నుంచి కాల్ వస్తుంది ఇండియన్ పోలీస్కి. అంటే మేకింగ్ అది చేస్తాను ఇది చేస్తానని అట్లా. ఇండియన్ పోలీస్కి అర్థం కాదు, ఒక మనిషి ఒకే నెంబర్ నుంచి ఇన్ని ప్రాంతాల నుంచి ఒక్కసారి ఎలా చేయగలుగుతాడు. దిస్ ఈజ్ ది డార్క్ సైడ్ ఆఫ్ ది ఎలక్ట్రానిక్ రికార్డ్ సార్. ఇదంతా తెలియాలి. ఇట్స్ నాట్ సో ఈజీ టు డిసైడ్ ప్రొబేటివ్ వాల్యూ. సపోజ్ ఈ కోడ్ మారుతుంది అనుకోండి, కాల్ ఎక్కడి నుంచి చేస్తున్నట్టు డిఫరెంట్ ప్లేసెస్ నుంచి కదా. అది నోన్ యాజ్ స్పూఫింగ్ టెక్నాలజీ. అంటే మీ మొబైల్ నెంబరు నాకు తెలిస్తే I can purchase some software known as spoofing software by paying $1 to US or African countries. They will be producing that software. With the aid of that software, I can use your number to send messages. The receiver will see your number. CDR లో తీస్తే సిడిఆర్లో రాదు ఇది, ఎందుకంటే మీ నెంబర్ నుంచి వెళ్ళలేదు కదా, మీ సిడిఆర్లో మీరు కాల్ చేసినట్టు ఉండదు. కానీ ఫస్ట్ ఇన్స్టాన్స్లో మీరు నాకు కాల్ చేశారంటే మీ నెంబర్ నాకు అనిపిస్తుంది. అర్థమైందండి? స్పూపింగ్ టెక్నాలజీ. సిమిలర్లీ సేమ్ గోస్ విత్ ఈమెయిల్స్, ఫేక్ ఈమెయిల్స్, సేమ్ స్పూపింగ్ ఈమెయిల్స్. మీ ఈమెయిల్ నాకు తెలిస్తే యూజింగ్ ఫేక్ ఈమెయిల్ సాఫ్ట్వేర్ I can send an email to anybody as if you are sending the email. I will take a printout. It may contain your email number, receiver email details, showing content of the message with 65B certificate. Does it mean to say that you send the email? Then how to analyze forensically email? ఈమెయిల్ ఎలా చూడాలి? బేసిక్ నాలెడ్జ్ మీకు ఉండాలి. ప్రతిదానికి ల్యాబొరేటరీ కాదు, ముందు మీకు తెలియాలి కదా. ల్యాబొరేటరీకి పంపించాలంటే మీరు అప్లికేషన్ రాయగలగాలి కదా, ఈమెయిల్ ఏ విధంగా తప్పని జడ్జి గారికి చెప్పాలి కదా. సార్ ఈమెయిల్ ఈ విధంగా కరెక్ట్ అనిపించట్లేదు, ఇట్ రిక్వైర్స్ రిపోర్ట్ ఆఫ్ ది ఎగ్జామ్ ఆఫ్ ఎలక్ట్రానిక్ రికార్డ్ అని అడగాలి కదా. 45లో జస్ట్ 45 రాసి పిటిషన్ పడితే ఎలా అవ్వదు కదా కోర్టులో. ఈమెయిల్స్కి హెడర్స్ అని ఉంటాయి. హెడర్స్ కమ్ టు దట్. హెడర్స్ ని చూడాలి. హెడర్స్ లో దట్ విల్ షో వెదర్ ఇట్ ఈస్ జెన్యూన్ ఈమెయిల్ ఆర్ ఫేక్ ఈమెయిల్. మొబైల్ నెట్వర్క్ 11. వాట్ ఈస్ 11? దెన్ యూ విల్ కమ్ టు 11. LAC. This is known as LAC. What is meant by LAC? Local area code. Local area code means where suppose ఎక్కడి నుంచి అయితే పంపిస్తున్నామో దాని లోకల్ ఏరియా. సపోజ్ విజయవాడ నుంచి వెళ్తుంది అనుకోండి, విజయవాడ ఎయిర్టెల్ ఒక లోకల్ ఏరియా కోడ్ ఉంటుంది. సపోజ్ ఆ కాల్ హైదరాబాద్ నుంచి మలక్పేట నుంచి వెళ్ళింది అనుకోండి, మా ఏరియా నుంచి, ఆ మలక్పేట లోకల్ ఏరియా కూడా వస్తుంది. దెన్ లాస్ట్ నెంబర్ LAC + CID = సెల్ ఐడి అంటారండి దీన్నే. CID లాస్ట్ ఇది CID సెల్ ఐడి. ఈ నెంబర్లు అన్నింటినీ కలిసి సెల్ ఐడి అంటారు. ఇదే లాస్ట్ సెల్ ఐడి, ఫస్ట్ సెల్ ఐడి. అంటే రిసీవర్ సెండర్ సెల్ ఐడి, రిసీవర్ సెల్ ఐడి. ఇది ఈ విధంగా చూడవచ్చు అని మనకు తెలిస్తేనే అది కరెక్ట్గా మనం ఎక్కడి నుంచి వెళ్ళింది కాలు, ఏ స్టేట్ కంట్రీది, ఏ స్టేట్ సర్వీస్ ప్రొవైడరు, ఈ లోకల్ ఏరియా కోడ్ ఏంటి, సెల్ ఐడి ఏంటి అని తెలియాలి. దిస్ ఇస్ రిలవెంట్ టు మొత్తం ఈ టోటల్ నెంబర్ని కలిపి సెల్ గ్లోబల్ ఐడెంటిటీ ఐడెంటిఫైర్ అంటారు, CGI. Its short form is CGI. Total all numbers are known as CGI. Cell Global Identity. Tower dump. Tower dump means CDR of the tower. Then phones, different types of phones ఉంటాయి. టెక్నాలజీ 4G అని 5G అట్లా అంటున్నామో అట్లా ఒరిజినల్గా టెక్నాలజీ ఎలా స్టార్ట్ అయిందని. ఆపరేటింగ్ సిస్టమ్స్, దిస్ ఆల్సో మస్ట్ బి వెరీ ఇంపార్టెంట్. యూ మస్ట్ నో. ఎవిడెన్స్ కలెక్ట్ చేస్తారు కదా మొబైల్ ఫోన్లోంచి. ఆండ్రాయిడ్ ఆపరేటింగ్ సిస్టమ్, యాపిల్ iOS సిస్టమ్ మీరు వినే ఉంటారు. మెనీ పీపుల్ ఆర్ యూజింగ్ యాపిల్ ఫోన్స్, మెనీ పీపుల్ ఆర్ యూజింగ్ ఆండ్రాయిడ్ ఫోన్స్. There are two different types of operating systems. What is operating system means? Which is useful to run the phone. అది ఆపరేటింగ్ సిస్టమ్ సంబంధించి స్టోరేజ్ అంటే డేటా స్టోరేజ్ డిపెండ్స్ అపాన్ ది ఆపరేటింగ్ సిస్టమ్. ఆండ్రాయిడ్లో ఒక విధంగా స్టోర్ అవుతుంది డేటా, యాపిల్ ఫోన్లో ఒక విధంగా స్టోర్ అవుతుంది. రికవరీ చేసేటప్పుడు ఆండ్రాయిడ్ ఫోన్లో కొన్ని మాత్రమే రికవరీ చేయగలుగుతారు, యాపిల్ ఫోన్లో కొన్ని మాత్రం. యు నో ది సెక్యూరిటీ ఆఫ్ ది వై యాపిల్ సిస్టమ్ ఈజ్ మోర్ సెక్యూర్డ్ మీన్స్ ఇట్ డజంట్ అలౌ టు రికవర్ certain things. Even they said no, even to the FBI. మేము ఓపెన్ చేయమని చెప్పారు వాళ్ళు. FBI of course ultimately through some hackers could able to crack the system, but company refused due to its security policy US లో. అంటే మనకి అది కూడా ఐడియా ఉండాలి. యాపిల్ ఫోన్లో తీసేసే ఉంటాడు వాడు. నిజానికి అది యాపిల్ ఫోన్లోంచి ఇది ఈ టైప్ ఆఫ్ డేటా ఎక్కడ స్టోర్ అవుతుంది, దీన్ని రికవరీ చేయడం సాధ్యమేనా అనే విషయం మనకు తెలియాలి. లేదంటే యాపిల్ ఫోన్ నుంచి రికవరీ చేసామని చెప్పి డాక్యుమెంట్ పాడేస్తే మనకి యాపిల్ ఫోన్ నుంచి ఇది రికవరీ చేయడం సాధ్యమేనా అన్న ఆలోచన లేకపోతే వీ కెనాట్ డిఫైన్ ది అక్యూజ్డ్. దిస్ ఈస్ రిలేటింగ్ టు CDR, sir. I'm not going to detail more than. Then we are coming to mails. మెయిల్స్, ఒక మెయిల్ ఎలా వెళ్తుంది అనేదండి. మెయిల్ పంపిస్తాం కదా, ఎలక్ట్రానిక్ మెయిల్. హౌ ఇట్ విల్ గో? నరేష్ ఈజ్ సెండింగ్ మెయిల్ ఫ్రమ్ హైదరాబాద్ యూజింగ్ రెడిఫ్ మెయిల్. అంటే గూగుల్ మెయిల్, రెడిఫ్ మెయిల్, యాహూ మెయిల్, యు నో ది దే ఆర్ ప్రొవైడర్స్. దే ఆర్ ప్రొవైడింగ్ సర్వీస్ టు అస్ జస్ట్ లైక్ ఎయిర్టెల్, వోడాఫోన్, BSNL, etc. Google is providing mail service. Rediff is providing mail service. Yahoo is providing mail service. They are service providers. They are sending mails. Rediff mail. మనం ఒక లెటర్ పోస్ట్ చేస్తే హైదరాబాద్లో ఢిల్లీ ఎలా చేస్తుందంటే ఢిల్లీ నుంచి నాగపూర్, నాగపూర్ నుంచి భోపాల్, భోపాల్ నుంచి ఢిల్లీ ఇట్లా వెళ్తుంది లెటర్. ప్రతి పోస్ట్ ఆఫీస్ పూర్వం మీరు లెటర్ చూస్తే యూజ్ టు హ్యావ్ స్టాంప్స్ ఆఫ్ దట్ పోస్ట్ షోయింగ్ ఇది స్టాంపింగ్, డిజిటల్ స్టాంపింగ్. అంటే అది ఆ రూట్ లో వెళ్ళింది అని చెప్పడానికి. అలాగే మెయిల్ కూడా ఇట్ విల్ హ్యావ్ డిజిటల్ స్టాంపింగ్ లైక్ CDR. మొబైల్ ఫోన్ లో మన CDR ఏ విధంగా ఉంటామో మెయిల్స్ వచ్చేసరికి దాన్ని ఏమంటారు? డూ యు నో వాట్ ఈస్ ది డిజిటల్ స్టాంపింగ్ ఆఫ్ ఈమెయిల్ ఇస్ నోన్ యాజ్? It is known as header. Make a note of it. Digital stamping of an email is known as header. you must read the header to know whether it is a genuine mail or a fake mail. Every mail will have an header. మీకు ఏం చేస్తారంటే కోర్టులో 65Bతో మెయిల్ ప్రింట్అవుట్ ఇస్తారు కదా, దే విల్ టేక్ ఏ ప్రింట్అవుట్. 65Bలో ప్రింట్అవుట్ అని ఉంటుంది కదా, దే కెన్ ఆల్సో ఫైల్ ప్రింట్అవుట్ అవుట్పుట్ ఆఫ్ ది కంప్యూటర్. దే విల్ టేక్ ఏ ప్రింట్అవుట్ ఆఫ్ ది ఈమెయిల్, దే విల్ అటాచ్ a 65B certificate and produce it. Automatically court will admit it. But how do you find it is a fake mail or a genuine mail? That is the question before the court. Being the advocate, you must assist the court to arrive at a proper and right conclusion. Header, you have to verify the header. Header ni ela verify cheyali? Mail ante mail open chesthe dantlo header ni మనం ఓపెన్ చేయొచ్చు. మీకు ఒక ఆలోచన రావచ్చు, ఇక్కడ ఒక ప్రశ్న అడగాలి. యూ మస్ట్ ఆల్ ఆస్క్ మీ వన్ క్వశ్చన్. సార్, ప్రింట్అవుట్ వేసినప్పుడు ఎడిట్ చేస్తారు కదా, అంటే ఫర్ ఎగ్జాంపుల్ డేట్ కానీ టైం కానీ కంటెంట్ కానీ. Yes, there is a possibility because they will download it into text form and take a printout. While taking printout, they can edit the text. But మీరు ఎప్పుడైనా ఒకటి గమనించారా, మెయిల్ పంపించారు, notice when you send an email through system using by you, did you find that anything is saved in your system? మీ సిస్టంలో సేవ్ అవ్వడం చూసారా ఎక్కడైనా? Nothing will be saved in your system. Where it is saved? It is saved in the service provider server. Means Google Mail ఉంది. మీరు ఏం చేస్తారు? బ్రౌజర్ ఓపెన్ చేస్తారు. అంటే గూగుల్ క్రోమ్ కానీ ఫైర్ ఫాక్స్ కానీ సఫారీ కానీ, these are known as browsers. You will open a browser. You will type the email address. Then you will get a page having login page, mail login page. You will enter your name and password, username and password. Then you log into your mail account. Where do you do all this work? You are doing all this work in the server of the service provider. You are not doing anything in your system. Even if you change timing of your system, you cannot change the timings in the server of the service provider, because you have no such permissions. You will not give any such permissions. You just use it only as a typing pad, nothing more than that, and sending the message. Meek mail doubt unte, you can compare it. It will be available in the service provider server. You can call for the records of the service provider. They will provide, because they are intermediaries, section 7, Adv. section 67C. Those who are operating in India shall also maintain the records for certain period as stipulated by the central government. Or you can ask the opposite party to open the mail in live. Live lo open chesthe, it comes from the server. You can compare both and find out whether date, time, content, because sometimes in civil contracts, date is more important, time is more important, content is more important. So also in criminal cases. Header looks like this. Header lo entante fake mails is the most dangerous thing for emails, sir. Ante if I know your mail address, I can send mail using your mail address as if you are sending the email. So if you verify the header, if it is a genuine mail, it will have service providers relays. Gmail, suppose it is sent to Gmail, header will have Gmail relays of the service provider. If it is a fake, it won't have any Gmail relays. So you have to, that is why you have to request the opposite party also to provide header copy, so that you can analyze the header to find out whether it is a genuine mail or a fake mail. Genuine mail header looks like this. It shows Gmail relays or Rediff mail passing through genuine servers. But fake mail will not have these headers. This is regarding email, sir. I am cutting short of details due to paucity of time. But I am only sharing the basic information. I am not going to details of technologies. Fake email. Fake email header looks like this because it contains only the relays of the service provider who is providing fake email. They can be easily identified. Then coming to CCTV, sir. Do you know how to give a Section 65 certificate? Very famous case, Mumbai High Court case. When CCTV cases are concerned, I request all of you to read one judgment of Madras High Court. Every advocate shall read that judgment. Of course, that judgment was, to some extent, was set aside in Arjun Panditrau's case regarding 65B only. Regarding 65B only, that case was set aside as not good law. But the functioning of CCTV, how a CCTV would function, its technology, how it happened, how CCTV works, was very lucidly explained by the Madras High Court in that judgment. Even law students shall go through that judgment to understand the functionality of a CCTV and its importance. That is famous case K. Ramajayam alias Appu versus Inspector of Police, 2016 lawsuit Madras 136. K. Ramajayam alias Appu versus Inspector of Police, 2016 lawsuit Madras. I'll just show you. CCTV would be like this, sir. Generally, video switcher will be there, to which cameras will be connected, other side will be connected to a monitor and a recorder, video recorder. Generally, the data will be stored in it. Cameras will capture the image. They will send it to video recorder where data is processed and stored. Well, image, they will capture the image or video, cameras. Then that image or video will be converted to machine language and stored in the video recorder. That is why process is involved. Computer process is involved. Capturing a photo is one thing, but converting the photo and video into machine language, computer language, and storing it in a hard disk. This process is known as computer process, processing of data. That is why it falls under the category of electronic record, DVR. This is known as DVR. Video recorder is generally known as digital video recorder, DVR. You might come across these words when confronting the CCTV footage. It have different systems, analog system, CCTV working on analog system, IP based system, internet. మీరు చూసే ఉంటారు ఇండివిజువల్గా పనిచేసే CCTVలు, ఇంటర్నెట్ మీద పనిచేసే CCTVలు. Those are known as IP based systems. Functionality is different. What is DVR? This is the important part in a CCTV footage. This will record the data recorded by the cameras will be stored in this DVR. Police will go to there, they will download the data into some other gadget and they will play it in another computer. That is why 65B certificate is required. Originally stored in DVR. They can't bring the DVR. If they start bringing DVRs, the owner has to purchase new DVRs every time. Suppose if it is a railway station or bus station, many things will happen. Many CCTVs will be there. Every day, some offences will be happening in railway stations and police stations and some other public visiting places. If police starts collecting DVRs in every case, it is impossible for the system to maintain DVRs. That is why they will download and store it. 65B certificate necessity is there. While means that DVR is working properly at the relevant point in time, it is maintained properly, something like that. 65B condition, 4 conditions are there. They will comply it. This is DVR. Standalone DVR, network, NVR, network. Now present days we are using these network video recorders. PC based DVR. Generally in homes we are using these PC based DVRs. Small houses. How a DVR should be there? DVR. The problem in DVRs is CCTV location is also important to understand the CCTV footage. Documentation, steps to how police will collect. Challenges. Challenges means used by the agencies, experts, to cross-examine them. You must ask them, what is the tool used by you? What is the percentage of success of the tool? Any one of you know the Adv.R. principles? Adv.R. principles. Sir, long ago, Indian Apex Court recognized the Adv.R. principles in India. Very long ago. Adv.R. principles means American Supreme Court has laid down certain principles in a case of filed by Adv.R. They are famously known as Adv.R. principles. Those principles rendered by American Supreme Court was accepted in India by our Apex Court as standard. Means suppose if a tool is developed to analyze a particular software, you must know this also. The tool must be a standard tool. Suppose if I prepare one tool, you prepare one tool, you prepare one tool, they will develop different reports. For example, postmortem report is there, anatomy, forensic medicine. They will give a report. Why you are accepting it as a standard report? Because it is a standardized report based on medical science, forensic science. Likewise, in electronic records, there must be certain standards to analyze any electronic record. They need certain tools to analyze certain records. For that, certain standards be maintained internationally, popularly known as Adv.R. principles, as rendered by American Supreme Court. They were accepted in Selby's case. Do you know? Yes, sir. They are known as Selby's case. Make a note of it, sir. Selby's case is famous for narcotic test. Selby's case, you read Selby's case. In Selby's case, they said Adv.R. principles can be accepted in India also. One of the standardized tools is AMPED-5. It is used in India also. Its accuracy is very good. That is why Indian laboratories are also using this AMPED tool to analyze CC footage. So also, sir, finally, social media, WhatsApp, Facebook, Twitter, whatever it may be. They are applications provided by the service providers. We are using the applications to transmit information either through calls or messages. The problem is same, fake. So you must know the basics of WhatsApp, so also Facebook, Twitter, etc., how they would function, whether this is a genuine report. Because by using fake WhatsApp application, I can create as if you send a message to another. I can produce with 65B certificate. It doesn't make the day. You have to analyze it, whether it is a genuine message or fake message. So these are the basics, sir. Because of the passage of time, I am concluding here. So law is one thing. Other side of the coin is forensics of the electronic records. Law I also discussed with you. But you must also aware of the basic things of the forensics of electronic records, so as to successfully analyze, read it and come to a proper conclusion, whether it is a genuine one or a fake one. Then only we can do some justice to our parties or respective clients. Thank you, sir. Thank you for giving me this opportunity.
Thank you, sir. normal morning 2 sessions, we oftenly hear on those subjects. But it is a different subject, new subject. Majority of us not familiar with this particular subject, but today most of us become familiar with this. Well, I am afraid of using that scoop technology. Don't use that technology frequently. It's only for the purpose for which it is intended to be used. And my dear friends, very elaborately, not only the law, but also technology was explained to us. And we are thankful to Sri Justice Chakravarti Garu, big way. I request our colleagues, Sri Brahmanand Reddy Garu, Ravi Guvera Garu, Brahma Reddy Garu, Sudarshan Garu to come onto the dais to felicitate the Honorable Sri Justice Chakravarti Garu. After sumptuous lunch, organizers served us coffee, tea, one after the other to raise us up. So I request please have patience, another 7-8 minutes. We will conclude the entire program. I request Sri Divakar Babu Garu, Principal, Siddhartha Law College, to come on to the dais. Though it is a very short time, we would not have done this in this manner, but for the support given by the Divakar Babu Garu and his team of the students and faculty members. I request the members, Bar Council members, Ajay Kumar Garu, Sunkar Rayana Prasad Garu, Malleswara Garu, to join with us to felicitate Divakar Babu Garu. More than one occasion, Divakar Babu Garu always assure us, please come and organize a program and we will cooperate with you. On the befitting manner, they have cooperated with us, made this program a grand success.
Thank you, Andy. Now I take privilege to honor the Chairman, AP Bar Council, Mr. Ganta Ramarao Garu. Please come on dais to felicitate him. I request all the members, Bar Council members, Bellara Bar Association President, Secretary, and Vice President, all my governing body members, along with Chalsan Ajay Kumar Garu, Sunkar Rajendra Prasad Garu, S. Malleswara Garu, please come on to the dais. I take privilege, the Vice Chairman of Bar Council of Andhra Pradesh, Sri Ram Yogeshwara Garu, please come on dais. He will be felicitated by P. Sivakateswara Rao and Sappa Ramesh. Please come onto the stage. Sappa Ramesh. Sivakateswara Garu, please come. And now I request my colleague, Joint General Secretary and Vice President will felicitate him. Sappa Ramesh, please come onto the stage. I call upon Mr. Bar Council of India member, Sri Ram Reddy Garu. Please come onto the stage. Allam Padmanabha and P.V. Prasad Garu, senior members of the Adv.R. Bar Association, please come onto the stage and felicitate him. Thank you, Andy. Now I call upon the senior member of the Bar Council of Andhra Pradesh, Mr. K. Chidambaram Garu, please come onto the stage. Mr. Chilankurchi Satish. Thank you, Andy. Thank you. Next to V. Brahma Reddy Garu. Mr. Sai Lakshmi Garu, please come onto the stage. Thank you, sir. And the another is senior most Bar Council member, Mr. N. Dwarkanath Reddy Garu, please come onto the stage. And now I request S. Samsara Garu for the stage. Thank you, sir. Next, Madam Madhavi Garu Rolla. Please come on to the stage, Madam. Swarupa Reddy, please come to the stage. Thank you, ma'am. Thank you, ma'am. And another senior most member of the Bar Council of AP is represented from Visakhapatnam, Ma Anna, Sri S. Krishna Mohan Garu. Please come on to the stage. నేను విశాఖపట్నం లా కాలేజీలో చదువుతున్నప్పుడు అప్పటికే సీనియర్ లాయర్ మా అన్న ఐ నో హిమ్ సిన్స్ లాంగ్ టైం. కృష్ణమోహన్ గారు. కె రవికుమార్ గారు. డాక్టర్ కె రవికుమార్ గారు ఈజ్ అ సీనియర్ మెంబర్ ఆఫ్ ది బార్ and president for Rotary Vijayawada, Rotary Club of Vijayawada. Thank you, Anna. Thank you. And the next, Brahmananda Reddy Garu, please come on to the stage, sir. Mr. Chantraj Anna will honor him. Chantraj Garu. Mr. P. Ravi Guvera Garu, please come on to the stage. Ravi Guvera, please. V. Koteswara Garu will honor. Koteswara Garu. Thank you, sir. And another one more senior member of the Bar Council of AP is representing from the Visakhapatnam Bar Association, Mr. P. Narsingrao Garu. Please come on to the stage. Narsingrao Gari Mrs. Mako Madam ma college lo, so still I remember him. Thank you, sir. Please come. Sridev Madam Garani Mako college lecturer, vari husband Narsingrao Garu. Appadi nunchi naku I know him since long time. Please come on. Mr. P. Pratap. Pratap will come on. Thank you, sir. Next, Mr. G. Sudarshan Rao Garu. Please come on to the stage, sir. My secretary, General Sridhar, will honor. Thank you, sir. The Vijayawada bar members are also here. And as first I call upon Mr. Chalsan Ajay Kumar Garu. Please come on to the stage. Dadla Lakshman Rao Garu. Chandrasekhar Garu, please come. Thank you, sir. Thank you, Ajay Kumar Garu. Next is Sunkar Rajana Prasad Garu. I request Sunkar Rajana Prasad Garu to come on to the stage. Representing from Vijayawada, Ajay Kumar Garu, Sunkar Rajana Prasad Garu, and G. Lavanya and K. Nilima, please come onto the stage. Thank you, sir. Thank you. Another senior member representing from Vijayawada, Sri S. Malleswara Garu, please come on to the stage. B. Venkata Satyanarayana, S. Srinivas from all many member of Law College, please come on to the stage. We'll honor Shankar S. Malleswara Garu. I special thank to all the Bar Council members, especially my special thanks to Chairman, Bar Council of Andhra Pradesh, Mr. Kanta Ramarao Garu, has given an opportunity to conduct this seminar in Vijayawada, which is useful to all the members of the bar and as well as the students of the Siddhartha Law College. So I special thank to the Bar Council members and Chairman and other dignitaries. I special thank to Mr. Chalsa Ajay Kumar Garu, Shankar Rajendra Prasad Garu, S. Malleswara Garu. These three members are belongs to Vijayawada, and I appreciate them for all the events. They are fully cooperated to the association and they are leading us. Really, they are my leaders. Ajay Kumar Garu, Shankar Rajendra Prasad Garu, Malleswara Garu, all these three. In fact, these three members are my leaders. So I appreciate especially the three members. What are the programs conducted by the Adv.R.Balaji Bar Association, and these three members are always stood, they have lead the entire Bar Association. So a special thank to all the seniors of three members of the Vijayawada. Thank you once again. Thank you, sir.
Thank you, thank you. One of the important participant association and the president who came forward and cooperated with us, because to do these kind of things along with the praise also criticism will be there. Many things he has taken into his stride because of the problem of short time. I request my fellow members, local members Vijayawada, Ajay Kumar, Shankar Rajendra Prasad, Malleswara Garu, to join with me to felicitate the president of the association. Now, vote of thanks by Mr. Srinivasrao, Vice President of the Vijayawada Bar Association.
Honorable Judges of AP High Court, respected ST members and Chairman of AP Bar Council, Honorable Judicial Officers, my Gurus of SVD Siddhartha Law College, especially Principal Dr. C.H. Divakar Sir, Senior Advocates, my colleagues, budding lawyers, and entire legal fraternity, good evening. I, Srinivasrao Puppala, Vice President of Adv.R.Balaji Bar Association. It's great pleasure and privilege to sum up today's seminar. At the outset, on behalf of Bar Council of AP, the Adv.R.Balaji Bar Association and Srimati SVD Siddhartha Law College, let me pay my extreme regards to the respected dignitaries who have participated in this seminar. Firstly, my vote of thanks to our chief guest, humble and kind-hearted person, Honorable Sri Justice A.V. Seshashayi Garu, for his gracious presence and enlightening and inspiring lecture to the aspirants and legal fraternity. We owe our profound thanks to Honorable Sri Justice U. Durga Prasad Garu for his gracious presence and breathtaking lectures to us. Our immense thanks and gratitude to Honorable Sri Justice D.V.L.N. Chakravarti sir for thought-provoking and innovative lecture on electronic evidence. Your Lordship, lecture on electronic evidence has enhanced our understandings on electronic evidence. Our sincere thanks and gratitude are due to Bar Council staff, convener and members, Bar Council of AP, especially our Chairman Sir Ganta Ramarao Garu, staff of BBA, Executive Committee of BBA, my advocate fraternity, and Principal Sri C.H. Divakar Garu, SVD Siddhartha Law College, for their sincere efforts for organizing this workshop in a grand manner. I would like to take this opportunity to thank the management, principal and staff of Belagapuri Ramakrishna Siddhartha Engineering College. And last but not least, I profound my thanks to print and electronic media. Thank you all. Thank you very much. And now the national anthem. Please stand up.
For that, I congratulate all those persons who waited till now. Out of the more than 500, 135 people roughly are there in the hall. You passed the patience test. You fit to be advocates. Now the national anthem.
पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे ग्राहे तव शुभ आशीष मांगे गाहे तव जय गादा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे जय